Welcome to the Deep Dive.
Great to be here.
You've given us quite a stack of documents, haven't you? All about the latest on labor regulations here in India.
Yes, a significant collection covering the new codes and draft rules.
So the plan today is to act as your audio guide. We're going to meticulously comb through everything: the analysis docs, the actual codes on wages, OSH, industrial relations, Social Security, the gazettes, the lot. Our mission really is to pull out every single essential detail and lay it out clearly for you, the listener. Think of this as, well, a comprehensive audio replacement for wading through all those files yourself.
Absolutely. It's a complex landscape, these laws. They aim to streamline things, update them. So we'll focus on the core aspects, the really important takeaways from these specific documents.
Make sure you walk away with a solid grasp.
Exactly.
Okay, let's start maybe with something fundamental. The powers of the inspector cum facilitator. That role comes up in the analysis of Draft Central Labor Rules 2020 and also the Draft Central Rules on Code on OSH 2020.
Right, a key figure.
And one significant power they have is taking samples, substances, materials in a workplace.
Yes, but it's not just any time. They need a reason to believe something there could actually cause bodily injury or, pose a health risk to an employee.
So there's a trigger condition.
Precisely. And the procedure for taking that sample is very specifically laid out. It's not, as you said, arbitrary.
Okay, break that down for us. How does it work?
Well, the inspector cum facilitator has to divide the sample into 3 parts. This has to be done right there in the presence of a notified person from the establishment.
A representative.
Exactly. Unless, of course, that person deliberately stays away, willfully absents themselves.
Okay.
Then, each of these 3 parts is sealed and marked clearly. And crucially, the establishment's representative also gets the right to put their own seal and mark on the samples.
I see. So it's a kind of joint sealing process for transparency.
That seems to be the aim, yes. Maintaining integrity, providing checks and balances.
And these sampling activities, are they usually spontaneous or planned?
Generally, the rules suggest it's part of a planned inspection, something coordinated through the labor facilitation portal, and the employer gets notified beforehand.
Right.
However, there's also a provision. If the inspector cum facilitator genuinely suspects a direct violation of the code or the rules, they can take samples even outside that routine schedule.
So there's flexibility for immediate concerns.
Correct.
Okay, let's pivot a bit. Let's talk about money. Specifically, how the Employees State Insurance Corporation, the ESIC, handles its funds. We're looking at the analysis of Draft Central Labor Rules and the Draft Central Rules on Code on Social Security here.
Right. ESIC finances a big area. It seems the central government plays a guiding role in their investment strategy.
How so?
The ESIC has to invest its funds according to directions given by the central government. They can also open necessary bank accounts for, efficient administration, both generally and for specific schemes.
And who bears the risk or reaps the reward of these investments?
That's clear too. Any expenses or losses from investments are borne by the ESIC fund itself. Conversely, any profits or gains go straight back into the ESIC fund.
So it's self-contained financially in that respect.
Pretty much, yes.
The rules also define what counts as administrative expenses under Section 30, don't they?
They do, and it's quite specific. It includes fees and allowances for the corporation members, staff salaries, pensions, gratuities, office rent, furniture, repairs, basically all the operational overheads needed to run the ESIC.
That makes sense. But is there a limit on how much they can spend on administration?
Yes, and this is a key point. There's a hard cap. The total administrative expenses in any year cannot exceed 15% of the corporation's total revenue income for that year.
15%. That seems like a clear measure to ensure most funds go towards benefits, right?
Exactly. It prevents administrative costs from eating up too much of the contributions.
And are they just expected to stay under this limit, or are there active measures they need to take?
They're required to actively pursue cost control. The rules mention economy and staff costs, travel, printing, stationery. And importantly, they're also supposed to conduct evaluation studies.
Evaluation studies?
Yes, to assess how well the whole ESI scheme is actually functioning, to see if it's efficient and effective.
Okay, so continuous improvement is built in.
That's the idea. And just for clarity, when the rules mention the ESI scheme, it's a broad term. It covers the main program plus all related rules, regulations, notifications, and administrative directions from the corporation.
Got it. Comprehensive. Okay, let's move on to benefits. Sickness benefit. What do the analysis of draft central labor rules and the Social Security Code tell us here?
So the general eligibility for sickness benefit requires contributions for at least 91 days within any 2 consecutive contribution periods.
And the benefit amount.
The daily rate is set at around 70% of the person's average daily wages. It offers some income support during illness.
What about new employees, someone who hasn't worked long enough to meet that 91-day threshold?
There's a provision for them. If someone's new and has a contribution period shorter than 156 days, they can still qualify for sickness benefit if contributions were payable for at least half the number of days available for work during that shorter period.
Ah, okay. So it accounts for recent entrants.
It does. It acknowledges they need support too.
Are there times when sickness benefit isn't paid, even if someone is sick?
Yes, there's a specific exclusion. Benefit isn't granted for the first 2 days of sickness if it's part of a spell of sickness for which the person has already received benefit.
To prevent overlapping claims for short periods within one spell.
Essentially, yes.
Now, what if the sickness is longer term? Are there provisions for extended benefits?
Yes, for extended sickness benefit. This applies if an insured person is diagnosed with certain specified serious diseases. These are listed in corporation regulations.
Okay, what are the conditions?
They need to have completed the 4 contribution periods immediately before the diagnosis. They must have paid contributions for at least 156 days within those 4 periods. And they must have been eligible for the standard sickness benefit in at least one of those 4 periods.
So it's quite specific.
It is. And even meeting those contribution criteria is an automatic qualification for the extended benefit. They still need to meet all other general eligibility rules.
Right. And there was another point about first-time employees.
Yes, someone becoming an employee for the first time with less than 156 days contribution is entitled to medical benefit until the end of that corresponding benefit period, again, if contributions were payable for at least half the available working days.
And the extended sickness benefit rule.
Rule 23(1)(b) basically reiterates the conditions we just discussed, the 4 preceding contribution periods, and the eligibility for standard sickness benefit in at least one of them. It just reinforces those requirements.
Okay, clear. Let's move from sickness to disablement benefit. How is that handled?
The rules make a distinction between permanent total disablement and permanent partial disablement.
Let's start with total.
For permanent total disablement, where an injury results in a complete, lasting loss of earning capacity, the benefit is paid for the entire time the disablement lasts.
And the amount.
It's paid at the full rate specified in the schedule. This rate is linked to the percentage loss of earning capacity caused by the injury.
Okay, and permanent partial disablement.
This is when an injury causes a permanent reduction in earning capacity, but not total loss. The injuries covered are specifically listed in Part 2 of the 4th schedule.
So it has to be one of those listed injuries.
Generally, yes. For this specific calculation method, the benefit paid is a percentage of the full rate, the rate for total disablement. That percentage directly matches the percentage loss of earning capacity caused by that particular partial injury.
What happens if someone suffers multiple injuries in the same accident, say 2 different partial disabilities?
Good question. The rules say the benefit rates for those different partial disabilities groups, C and D specifically, are added together, aggregated.
Okay, so they stack.
They do, but there's a cap. The total combined benefit rate cannot go higher than the full rate that would be payable for permanent total disablement.
Right, prevents exceeding the maximum possible benefit.
Exactly.
Is it possible to get the disablement benefit as a lump sum instead of regular payments?
Yes, there's a provision for commutation. Periodical payments for permanent disablement can be converted into a single lump sum.
But it's not automatic, I assume.
No, definitely not. It requires a medical opinion. It must follow rules set by the central government. It needs a recommendation from the ESIC itself. And crucially, the lump sum must be based on the actuarial present value of the future payments.
So it's a calculated equivalent.
It has to be, to ensure fairness.
And the daily rate for disablement benefit, how is that calculated?
Generally, it's 90% of the average daily wages during the relevant wage period if the injury happens after the first wage period of that contribution period.
What if it happens very early, before completing that first wage period?
Then the calculation changes slightly. It's 90% of the wages the person actually earned, or what they would have earned if they had worked a full day on the date the accident happened. It accounts for those injured right at the start of the period.
Makes sense. Okay, let's talk about gratuity. Specifically, the nomination process. How does an employee nominate someone? We're looking at the analysis of draft central labor rules and the Social Security Code again.
Right, nominations. The employee needs to fill out a specific form, Form 3. This has to be submitted in duplicate to the employer.
How do they submit it?
2 ways. Either deliver it in person and get a formal receipt from the employer, or send it by registered post with acknowledgement due. Both methods create a record.
Are there deadlines for this?
Yes, there are timelines. For employees who already have a year or more of service when these rules start, they need to submit the nomination within 90 days, if they haven't already got one on file.
And for newer employees?
For those who complete 1 year of service after the rules come into effect, they have 90 days from the date they complete that year to make their nomination.
So it ensures everyone with a year's service gets it done relatively quickly.
That's the goal. The rules actually state that every employee completing 1 year of service must make a nomination.
Must make one. Okay. Can they nominate more than one person?
Yes, they can. And they can also specify how they want the gratuity amount divided among their multiple nominees.
Good flexibility there. And when it's time to actually claim the gratuity, say at retirement?
The eligible employee, or someone they formally authorize, needs to apply to the employer using a different form, Form 4.
And the timeline for that?
They should submit this application within 30 days from the date the gratuity becomes payable.
Okay, ensures the process starts promptly. Now let's shift to the broader legislation. The Code on Wages, 2019. We have the main PDF and the Gazette version here. What's the fundamental purpose of this code?
Its main goal is to regulate wages and bonus payments. And it aims to do this across all types of employment, wherever any industry, trade, business, or manufacturing happens. It's meant to be quite comprehensive.
I see. How is it structured?
It's organized into 9 chapters, contains 67 sections in total, and importantly, it defines 26 key terms that are used throughout the code.
And what are its stated intentions, beyond just regulation?
The text mentions promoting equity, labor welfare, and also the sustainability of businesses. The idea is that this framework will help catalyze economic growth and job creation.
A balancing act.
Supposedly, yes.
How does it define an establishment?
Very broadly, it's essentially any place where industry, trade, business, manufacturing, or any occupation is carried on. And significantly, this includes government establishments too.
So public and private sector covered. One of the core parts must be minimum wages, right? How does the code handle fixing those?
Yes, the appropriate government, central, or state, depending on the establishment, is responsible for fixing minimum wage rates. They can set rates for time work or for piecework.
What about piece rate workers? How do you ensure a minimum for them?
The government has to ensure a minimum rate based on time work, even for piece rate employees. So their earnings from piecework shouldn't fall below what a time worker would earn for similar effort.
Okay. And can the rates be set for different periods? Like daily, monthly?
Yes, the code allows for flexibility. Rates can be fixed based on various wage periods, hourly, daily, weekly, monthly, or any other period that might be prescribed in the rules.
Now, bonuses. How does the code calculate the allocable surpluses for bonus payments?
It lays out a specific calculation method, and this calculation needs to take into account amounts that have been set on or set off under Section 36. That section deals with how surpluses or deficits from previous years are carried forward for bonus purposes.
Okay. What if workers demand more than the minimum statutory bonus? Perhaps based on productivity.
Demands for bonus exceeding the statutory minimum, perhaps linked to production or productivity, are subject to agreements or settlements between the employer and employees or their unions.
Is there a limit on how high the total bonus can go?
Yes, there is. The total bonus payable to an employee in an accounting year, including the statutory minimum, cannot exceed 20% of the wages they earned in that year.
20% cap. Got it. The code sets up a central advisory board too, doesn't it? What's its role?
It has several advisory functions. It advises the central government on fixing and revising minimum wages. It also advises on increasing employment opportunities for women and the extent to which women should be employed in certain specified jobs or establishments.
Anything else?
Yes, it can advise on any other matter related to the code. And based on the board's advice, the central government can issue directions to the state governments.
So it influences policy across states?
Potentially, yes.
What about the inspector-cum-facilitator under this code? We touched on their powers earlier.
Here, they're explicitly deemed a public servant. Their role is twofold: advise employers and workers on complying with the code, and inspect establishments as assigned by the government following any official guidelines.
And penalties for non-compliance.
There are specific penalties. For instance, failure to maintain records or maintaining them improperly can lead to a fine up to 10,000 rupees.
What about other offenses?
For other violations, there's a step before prosecution. The inspector-cum-facilitator must first give the employer a written direction outlining the non-compliance and giving them a chance to rectify it within a specific time frame.
A chance to fix it first.
Yes. Prosecution only follows if they fail to comply with that direction. It encourages compliance over immediate punishment for potentially minor issues.
That seems reasonable. Now, the definition of wages itself is crucial. What does the code include and exclude?
It's quite detailed. Wages includes basic pay, dearness allowance, DA, and any retaining allowance.
Okay, the core components. What's excluded?
A fair bit. Exclusions are bonuses, the value of house accommodation or utilities like light water medical care, employer contributions to pension or provident funds, conveyance allowance, money paid for special work-related expenses, house rent allowance, HRA, payments under award settlement court orders, overtime pay, commission, and gratuity.
That's a long list of exclusions.
It is, but there's a very important proviso, a condition attached.
What's that?
If the sum of all those excluded payments is more than half 50% or another notified percentage of the total remuneration calculated, then the amount exceeding that half or notified percentage is actually treated as wages.
So you can't just load up the exclusions to artificially lower the wage component for calculating contributions or benefits.
Precisely. It prevents circumventing obligations linked to the basic wage.
Interesting mechanism. Does the code allow for other things to be considered part of bonus contributions?
Yes, the central government can prescribe other sums that might relate to the employer's contribution to bonus, provides some flexibility there.
And how is the employer's tax liability calculated for bonus purposes?
The direct tax payable by the employer is calculated at the rates applicable to their income for that specific accounting year. But, crucially, any carried forward losses from previous years under direct tax laws are not deducted when calculating this tax amount for the bonus calculation.
So bonus is based more on the current year's performance tax-wise.
Essentially, yes.
Okay, let's move to the occupational safety and health rules. The draft central rules on code on OSH 2020.pdf. What are some key takeaways here? Let's start with accident reporting.
Right, OSH rules. Accident reporting is critical. If an accident happens in an establishment, factory, dock, mine, construction site, and someone is injured and prevented from working for 48 hours or more immediately after.
48 hours or more.
Yes. Then the employer, owner, or manager has to report it. And quickly. By phone.
To whom?
Several parties.
Yeah.
The deputy commissioner, the subdivisional officer, the officer in charge of the nearest police station, and the family members or relatives of the injured or deceased person.
Immediate notification all around.
It seems designed for rapid response and information sharing.
What about returning to work after sick leave?
Employees need a fitness certificate before they can come back after being off sick for health reasons.
From any doctor.
Preferably from the qualified medical practitioner or medical officer who issued the original sick leave certificate. It ensures continuity and confirmation of fitness.
Makes sense. The rules also mention specific medical officers for certain employees?
Yes. Establishments employing working journalists or sales promotion employees must nominate one or more qualified medical practitioners as their designated medical officer as per Section 42 of the OSH Code.
And these specific employee groups, journalists and sales promotion staff, do they have different leave rules?
They do. They're entitled to 1 month's earned leave for every 11 months of duty completed.
1 for 11.
Okay.
And medical leave.
They can take medical leave on a medical certificate, and it can run consecutively with earned leave. However, there's a limit. The total duration of earned leave plus medical leave taken together can't exceed 120 days at one time.
120 days max continuous leave.
Correct. They also have an option to convert medical leave on half pay into half the amount of leave on full pay, gives some flexibility.
And provisions for longer illnesses like TB.
Yes, the rules mention provisions for medical examinations for these employees if they suffer from long-term illnesses like tuberculosis.
What about compensatory leave for working on holidays, etc.?
The rules state that compensatory leave should generally be granted so that no more than 2 such leaves are given in a single week.
Any exceptions?
Yes, workers in continuous processes might be exempt due to technical reasons.
And when should this leave be granted?
The establishment manager must grant it either by the end of the month in which the extra work occurred or before the start of the following month. So, fairly promptly.
Okay. Are there limits on overtime?
Yes, for certain categories of workers, overtime is capped at 125 hours in any quarter of a year.
Which categories?
It lists workers in continuous processes prone to breakdowns, those loading, unloading rail wagons or trucks, those facing exceptional work overload, and those in work notified by the central government as being of national importance.
So protection against excessive hours for specific demanding roles.
That appears to be the intention.
We touched on the inspector-cum-facilitator taking samples earlier. Does Rule 63 here add anything?
It essentially reiterates the power under Section 35(1)(x) of the OSH Code. The inspector notifies the employer, follows the inspection plan on the portal, and can take a sufficient sample of any substance if they believe it violates the code or rules. Standard procedure, but reinforced here.
Got it. The rules also define competent persons, specifically for mines. Who falls under this?
It's a broad list for mines. It includes the manager, overman, foreman, sirdar, mate, supervisor, also mechanical and electrical foremen and supervisors, surveyors, assistant surveyors.
Technical roles.
Yes, and also medical staff like qualified practitioners, dressers, compounders, chemists, assayers, metallurgists, welfare or personnel officers too. And finally, a catch-all. Anyone else the chief inspector-cum-facilitator deems to have supervisory or management capacity.
A very wide definition covering many roles.
It ensures key personnel across different functions are recognized.
What about rescue stations for mines? Section 72 is mentioned.
Right. Under Section 72, rules specify establishing rescue stations for underground mines, subject to the chief inspector-cum-facilitator's permission. These stations need specific extra equipment.
Like what?
At least 15 extra sets of breathing apparatus, each with a minimum 2-hour capacity. Plus, they need a team of at least 5 rescue-trained people, supervised by someone qualified and experienced, with at least 1 holding rescue room in charge qualifications.
Serious preparedness for emergencies.
Absolutely critical in mining.
The rules also get into qualifications for mine managers, don't they? Limited certificates for open cast and for oil mines.
Yes. For oil mine managers, for instance, they need a degree in engineering or industrial safety, or a post-grad diploma in industrial safety from specific institutes like the Central or Regional Labor Institutes. Plus, at least 5 years of management or supervisory experience in oil mines.
That sets a high bar for qualifications.
Ensures competence in critical roles. The rules also list the functions of a safety officer in mines, referencing Section 27(1) of the Code.
Can the chief inspector-cum-facilitator grant exemptions from some of these rules?
Yes, they have the power to grant exemptions, but only under specified conditions. Provide some flexibility where needed, presumably without compromising safety.
And vocational training in mines. Section 72 again, and Rule 140.
Yes, Rule 140 states that if there's any dispute about whether training is necessary for certain individuals or categories of mine workers, the chief inspector-cum-facilitator makes the final decision.
So they resolve ambiguities.
Correct. And Rule 141 mandates that every mine manager must ensure a training scheme is operational, following principles and practices directed by the chief inspector-cum-facilitator.
Training is clearly a major focus.
Consistently emphasized.
What about the vocational training board members? Their tenure.
Excluding the chairperson, members serve for 3 years from their notification date until reappointment or a successor takes over. They can resign. There are also restrictions if they're linked to certain institutions mentioned in Subrule 2D.
Conflict of interest avoidance.
He's likely.
What's the quorum for board meetings?
At least 1/3 of the members must be present. And crucially, that group must include at least 1 employer representative, 1 employee representative, and the chairperson.
Balanced representation needed.
Yes. Though staggered meetings are allowed if quorum isn't met initially on the same day.
Who chairs the meetings?
The chairperson presides. If absent, they can authorize another member to chair, granting them full chairperson powers for that specific meeting.
And decision-making.
By majority vote of those present and voting, assuming a quorum of at least 4, including the chair, is met. The chairperson gets a casting vote in case of a tie.
Can decisions be made outside meetings?
Yes, the chair can decide to circulate matters in writing for member consideration. However, if 2 or more members request a meeting discussion for a circulated item, it must be put on the agenda for a future meeting.
What's the secretary's role in meetings?
They present the list of business items to be discussed. They also record the minutes in a bound book, circulate copies to members, and the minutes are confirmed and signed by the chair at the next meeting.
Standard board procedures.
Pretty much. The rules also mention additional powers for the chairperson beyond what's specified elsewhere.
Does past experience exempt workers from the required training?
Not necessarily. Existing employees might still need pre-employment training under the specified scheme, regardless of their previous work. It standardizes training.
And each mine needs a training center.
Yes, every mine must provide and maintain an adequate training center. However, the chief inspector cum facilitator can authorize a common training center for 2 or more mines under the same management with recorded reasons and specific conditions.
For efficiency, perhaps. The rules reference various forms and registers too, right? Statutory returns, leave registers, overtime, accidents.
Yes, Schedules A, B, C for returns and specific forms, IV to ECI, for registers covering leave, overtime, compensatory leave, young persons, contractors, wages, muster roll, and accidents dangerous occurrences. Standardizes record keeping.
And abstracts of the code and rules need to be displayed.
Yes. Prominently in English and the local language understood by most workers, ensures awareness of rights and rules.
What about standing orders? The rules cover their submission and content.
Yes. The procedure for submitting draft standing orders for certification under Section 30. They list mandatory items for all establishments: recruitment, discharge, discipline, attendance, leave, etc.
And extra items for larger ones.
Correct. Establishments with over 100 workers need additional items: worker classification, shift work rules, temporary stoppages, termination procedures, and so on.
Can employers use model standing orders?
Yes, they can adopt Model 1s until their own are certified. The certifying officer can also direct amendments within a set period. Employers have about 6 months after the relevant chapter applies to get their modifications certified.
Safety committees in mines are also detailed.
Yes, including the manager as the employer rep and worker reps chosen in consultation with their registered trade union.
What are their functions?
Quite broad. Inquiring into accidents, diseases, suggesting prevention methods, promoting safety awareness, helping identify hazards, participating in audits, discussing safety reports, looking into potential dangers, and reviewing if their own recommendations are being implemented.
A proactive role.
Definitely intended to be.
We already covered rescue room in charge, qualifications and equipment, and the references to vocational training rules, 140, 141, 149, keep recurring. Seems like a strong emphasis.
Absolutely. Training, safety procedures, and preparedness are clearly central themes in the OSH rules for mines.
Okay, let's shift to the Social Security rules. Draft central rules on code on Social Security attached to 2021.pdf and the main Social Security code.pdf. What's a key point about fund usage?
One rule states that the main funds, excluding the admin account, cannot be used for direct payments into members' individual credit accounts or to their nominees' heirs.
Meaning the funds are for scheme benefits, not direct cash payouts outside those benefits.
That seems to be the implication. The funds are operated by officers authorized by the central board overseeing the scheme.
Rule 7 is mentioned regarding the standing committee's role.
Yes, it likely details how the standing committee assists the central board, the rules governing them, member terms, allowances, etc.
What about the corporation's power over property and loans? Section 27.3.
It outlines the conditions for the corporation, likely ESIC or EPFO, to acquire, sell, or transfer property, invest funds, raise loans, and repay them. The Director General can set conditions for property acquisition.
There's a process for employees or heirs to appeal gratuity issues. Form 6.
Yes, if someone is aggrieved by a notice about the gratuity amount, denial of eligibility, or the employer failing to issue a notice after an application, they can apply to the competent authority using Form 6 within 180 days for directions under Section 56.5.
Provides recourse.
It does.
How are maternity benefits paid?
A woman entitled gives notice to her employer using Form 11. The employer then pays the benefit and any other amounts due under the codal.
What if the woman passes away before receiving it?
Payment goes to her nominee. If there's no nominee, it goes to her legal representative, ensures the benefit reaches the intended family or estate.
Chapter 7 is mentioned regarding building and construction worker cess.
Yes, that chapter deals specifically with Social Security and the cess levied for those workers.
And the rules detail the cess collection and use.
Yes, the manner and time of collection, subsection 2, how the collected cess is used for worker welfare, subsection 3, uniform rates for advanced cess, subsection 4, the self-assessment process under section 100, and the method under section 103.1.
What information do employers need to submit about construction projects? Form XV.
Within 7 days of starting work or paying cess, whichever is earlier, they submit Form XV to the assessing officer. It needs employer details, work location, nature of work, start end dates, and estimated cost.
Keeps the authorities informed for assessment.
Right.
What powers does the assessing officer have?
They can accept the employer's self-assessment, issue their own assessment order, or issue a notice for further inquiry if they think the initial assessment is incorrect or incomplete.
Can employers appeal the assessment?
Yes, within 30 days, they can appeal to the appellate authority. The authority can then modify, annul, or return the order to the assessing officer for correction within a month.
A review mechanism. Okay. What about reporting job vacancies?
Employers in both public and private sectors must report vacancies to specified career centers before filling them, as per government notifications. Private sector establishments, or specified types, report to the regional career center from a notified date.
What details do they report annually? The EIR form.
Yes, by March 31st annually. It includes the number of employees, permanent, temp, contract, part-time, trainees, apprentices, their vocational distribution, details of new hires during the year, vacancies they couldn't fill, and estimated vacancies for the next financial year. The government can also require reporting to the Central Career Center.
A comprehensive workforce snapshot.
Designed to be, yes.
That's
Helps
it.
track employment trends and skill gaps.
What about aggregators and platforms engaging gig workers? Any obligations?
Yes, they have to submit provisional contributions for these workers. They need to report their annual turnover, estimate their liability to the gig platform workers, and calculate a provisional contribution.
How is that contribution calculated?
It's a minimum based on a percentage of their turnover and at least 5% of their estimated liability to the workers. A move towards Social Security for this segment.
We touched on gratuity applications earlier. Form 1 for employees, Form 2 for nominees years. What's the employer's timeline for payment?
The employer must determine and pay the gratuity within 30 days of it becoming payable. They also need to issue a written notice within that time to the recipient and the competent authorities stating the amount determined.
What if they delay payment?
Interest is payable on delayed gratuity from the due date until payment at a rate notified by the central government for long-term deposits. An incentive to pay on time.
Can the government set specific eligibility conditions for unorganized workers' benefits?
Yes, the appropriate government can notify specific conditions for unorganized workers to receive benefits under schemes framed by the code, allows for targeted support.
How do unorganized workers register?
Electronically, via a self-declaration-based application, including their ATAR number, submitted to the notified authority. Aims for streamlined enrollment.
What are the timelines for SSFOs submitting annual reports and accounts?
By September 30th, following the financial year end, a 30-day extension is possible with central government approval.
And the Controller and Auditor General, CAG, what powers do they have over these accounts?
Full audit powers. They can demand production of documents, books, records, and conduct thorough audits to ensure financial propriety.
Accountability check. Okay. How is the National Social Security Board for Unorganized Workers constituted?
By the central government. It includes a chairperson, representatives from employers, employees, central state governments, union territories, and the Director General Labor Welfare as member secretary. Members, besides the chair, should be eminent in fields like labor welfare, management, finance, law, administration,
A diverse board.
intended to bring wide expertise. The central government also prescribes nomination methods, terms, procedures, and how vacancies are filled. They can also set up advisory committees. State governments constitute state unorganized workers boards and building workers welfare boards.
Can members of these boards be removed?
Yes, by the government for reasons like no longer meeting eligibility, misconduct, or insolvency, but only after giving them a chance to show cause why they shouldn't be removed.
Due process. What about conflicts of interest?
If a member is a director of a company with a financial interest in a matter before the board committee, they must disclose it. The disclosure is recorded, and they cannot participate in any proceedings or decisions related to that matter.
Ensures impartiality. Good.
Yeah.
What's the liability for contract labor compensation?
The principal employer is liable to pay compensation. However, the contractor can recover the employee's contribution share from their wages. But the contractor cannot deduct the employer's contribution or admin charges from the employee's wages.
So the main burden stays with the principal employer.
Correct.
Can the corporation raise loans or set up funds for its staff?
Yes, they can raise loans with prior central government sanction, and they can establish provident or other benefit funds for their own officers and staff.
And all employees in covered establishments are insured.
Yes, every employee will be insured electronically or otherwise as prescribed by the central government. Aims for universal coverage within the scope.
What happens in permanent disablement cases? Referral to a medical board.
Yes, for assessment of earning capacity loss. There are provisions to review provisional assessments. Decisions can also be reviewed if new evidence shows non-disclosure or misrepresentation of a material fact.
Ensures accuracy. Who is eligible for medical benefits?
The insured person and their family under conditions, scale, and period prescribed by the central government. There are provisions for continued benefit after contribution cessation and for superannuated retired persons and spouses subject to conditions and possibly contributions.
Can civil courts overrule medical boards or ESI courts?
No, the rules state civil courts have no jurisdiction over matters decided by medical boards, medical appeal tribunals, or employees' insurance courts under this chapter.
So, specialized bodies handle these disputes.
Yes, and the ESI court has powers similar to a civil court for summoning witnesses, document production, oaths, evidence recording. It's deemed a civil court for certain procedural aspects.
There's a medical bonus for maternity cases.
Yes, 3,500 rupees, or as notified, payable to women entitled to maternity benefit if the employer doesn't provide free prenatal and postnatal care.
And leave for miscarriage or termination.
Yes, entitlement to leave with wages at the maternity benefit rate for 6 months upon providing prescribed proof.
Chapter 9 covers unorganized, gig, and platform workers. What kind of schemes are planned?
The central government will frame schemes covering life disability, health maternity, old age protection, education, and other benefits. State governments will also frame suitable schemes, a wide potential scope.
The rules also list matters that can be included in the EPF, pension, and deposit-linked insurance schemes.
Yes, they provide illustrative lists, employees' establishments covered, contribution rates, continuous service definitions, exemptions, records, investment patterns, withdrawal rules, etc. Gives an idea of the scheme frameworks.
Let's clarify some definitions from the rules. Continuous service for gratuity.
It means uninterrupted service, including absences due to sickness, accident, authorized leave, legal strike lockout, or work cessation not due to worker fault. Importantly, being laid off counts as continuous service. For gratuity eligibility, it specifically mentions working at least 190 days, underground mines establishments working less than 6 days a week, or 240 days, other cases, in the preceding 12 calendar months.
And superannuation.
Reaching the retirement age fixed in the service contract. For Chapter 3, gratuity, it's noted as 58 years.
Temporary disablement.
A condition from an employment injury needing treatment and temporarily preventing the employee from doing their previous work.
We covered wage exclusions earlier, bonus, HRA, overtime, etc. What about accidents happening when rules are broken?
An accident is still deemed arising out of and in the course of employment, even if the employee was acting against the law or employer's orders instructions, if the act would otherwise be deemed so and was done for the employer's business.
Broadens the scope significantly.
It does. Similarly, specified occupational diseases contracted in specified employments, listed in Schedules 2 and 3, are deemed injury by accident if the employee worked there for at least 6 continuous months. It's presumed work-related unless proven otherwise.
Recognizes inherent occupational risks.
Exactly. The rules list many diseases linked to substances like lead, phosphorus, mercury, benzene, chromium, etc. as occupational diseases.
The rules also reference sections on interest for delayed cess, 101, power to exempt from cess, 102, self-assessment timelines, 103, and penalties for non-payment, 104.
Yes, quick references to those specific sections within the Social Security Code itself, reinforcing those provisions. Also mentions the inspector cum facilitator's powers under Section 74 entry, examination, inquiry, taking statements, demanding documents.
Can the government grant exemptions from the whole code or schemes?
Yes, the central government can grant exemptions to establishments or employee classes, including government ones, subject to prescribed eligibility and compliance conditions, possibly needing renewal.
And the rules list matters. The central government, Sec 155, and appropriate government, Sec 156, can make further rules on And regulations for mines docs, Sec 157.
Correct. Sections 155, 156, and 157 outline the rulemaking and regulation-making powers covering a vast range of implementation details: ESIC, EPFO, gratuity, cess, unorganized egg workers, standing orders, conciliation, adjudication, safety, health, welfare, etc.
There's also mention of Social Security organizations assigning functions to officers and establishing a deposit-linked insurance fund.
Yes, allowing operational flexibility for the organizations, with the central government bearing associated costs, and establishing the deposit-linked insurance fund with employer contributions capped at 1% of wages, or as notified.
And the rules reiterate the points about accidents involving work transport or happening despite rule breaking being deemed work-related.
Yes, reinforcing those broad interpretations of arising out of and in the course of employment.
There's also an appeal process against orders under subsection 5.
Yes, appeal to the appropriate government or specified authority within 60 days, with a possible 60-day extension for sufficient cause.
And section 143 on exemptions is referenced again, along with the lists of matters the appropriate and central governments can prescribe rules for.
Correct. It just circles back to the broad scope of rulemaking powers granted under the code to fill in the operational details.
Okay, deep breath. Let's move to the final set. The Industrial Relations Code, 2020, its Gazette, and the draft Central Rules. When did this code become official?
It received presidential assent on September 28, 2020.
Who is the appropriate government under this code?
It depends. For central public sector undertakings, it's the central government, even if their equity drops below 50% after the code starts. For other establishments, including state PSUs and autonomous bodies controlled by the state government is the appropriate authority.
Important distinction for jurisdiction. What about works committees?
Required in establishments with 100 or more employees. Their goal is promoting good relations, discussing common interests, and resolving differences.
How are they composed?
Worker representation must be no less than employer representation. Worker reps are chosen from among the workers in consultation with their registered trade union.
Ensures worker voice. How is trade union registration handled?
Unions need to inform the registrar if membership falls below 10% or 100 workers, whichever is less. They also have to report changes in their details or constitution. A registered union becomes a body corporate, perpetual succession, common seal, can hold property, contract, sue, and be sued.
Legal entity status. How does a union get recognized as the sole negotiating union?
If a union has the support of 51% or more of the workers on the muster roll, verified as prescribed, the employer recognizes them as the sole negotiating union.
What if no union reaches 51%?
Then the employer constitutes a negotiating council. This includes representatives from all registered unions that have at least 20% worker support. Each union gets one rep for every 20% support they command.
A multi-union council, then.
Exactly.
How are parties represented in conciliation proceedings?
Employers can represent themselves or use an authorized person. Workers can be represented by their trade union or by 5 elected representatives if no union exists. For individual termination cases, the worker can represent themselves or use a union-authorized rep.
Can disputes be sent to arbitration voluntarily?
Yes, if both parties agree. The arbitrator investigate and submit a signed award to the appropriate government, which is binding.
How are industrial tribunals constituted?
Typically, 2 members appointed by the appropriate government. 1 judicial, 1 administrative. Benches can have both, or just a single judicial or administrative member. Qualifications and terms for central government tribunals follow rules under the Finance Act, 2017. The Constitution itself is considered final. There's also a National Industrial Tribunal for disputes of national importance.
What if tribunal members disagree?
They state the points of difference and refer them to the appropriate government. The government appoints another judicial member to hear just those points. The final decision is by majority of the original members plus the newly appointed one.
Resolves deadlocks. Are settlements and awards binding?
Yes, binding on all parties to the dispute, all current and future employees in the establishment, and the employers. Settlements are binding for the agreed period. Awards are usually binding for 1 year, extendable up to 3 years by the government.
Can a settlement or award be terminated easily?
A notice of termination is only effective if given by a party representing the majority of those bound by it. Prevents minority termination.
How can a worker recover money owed under a settlement or award?
The worker, or their refares, applies to the appropriate government. If satisfied, the government issues a recovery certificate to the collector, who recovers it as arrears of land revenue.
A formal recovery mechanism. Okay, Chapter 6 deals with layoff, retrenchment, and closure. What's continuous service here?
Uninterrupted service, including absences for sickness, accident, authorized leave, legal strike lockout, or work cessation not due to worker fault. Being laid off counts as continuous service.
When is a worker not entitled to layoff compensation?
If they refuse suitable alternative employment nearby at the same wage without needing special skills, if they don't report for work daily during the layoff, or if the layoff is due to a strike slowdown by other workers in the establishment.
Conditions apply. What needs to happen before retrenching someone with a year's continuous service? Chapter 6.
1 month's written notice with reasons, or pay in lieu, plus payment of retrenchment compensation, 15 days average pay for each completed year of service.
And this chapter overrides inconsistent laws.
Yes. For Chapter 6, industrial establishment means a factory, mine, or plantation as defined in their respective acts.
Now, Chapter 7 has special provisions for larger establishments, right? 300 plus workers. What about layoffs there?
Yes, for establishments with 300 plus workers, average in preceding 12 months, prior permission from the appropriate government is needed for layoffs.
Any exceptions?
Yes, exceptions for power shortages, natural calamities, or in mines, specific issues like fire, flood, gas, explosion. Employers apply stating reasons and number affected. The government inquires and grants or refuses permission.
And retrenchment in these larger establishments, Chapter 7.
Also needs prior government permission. Conditions are stricter. 3 months notice, or pay in lieu, plus the standard retrenchment compensation, 15 days pay per year. Employers apply with reasons, government inquires, and must decide within 60 days.
Can the government review its own permission decisions or refer them?
Yes. The government can review its orders on granting, refusing permission under Chapter 7, or it can refer the matter to a tribunal for adjudication. The tribunal must issue an award within 30 days of the reference.
What about closing down an establishment entirely? Notice requirements.
At least 60 days notice must be given to the appropriate government using Form 9, with copies served to the recognized trade union and affected workers via registered speed post and email.
Do these layoff retrenchment closure rules, Chapter 6 and 7, apply to all establishments?
No, they don't apply to seasonal establishments, or those with fewer than 50 workers, or those operating for less than 12 months. Exemptions for smaller seasonal operations.
Are there penalties for violating Chapter 7 rules, the ones for larger establishments?
Yes. Fines up to 50,000 rupees for initial contravention. If it continues, a daily fine up to 2,000 rupees can be imposed.
Discourages non-compliance. The rules specify forms for seeking permission, BIA and 7.
Yes. Form EIA for retrenchment permission, Form 7 for closure permission under Chapter 7. Annexure I details the required info, worker details, reasons, etc.
What about reemploying workers retrenched due to transfer of the business?
The new employer must give preference to them if their names are on a waiting list from the old employer and they offer themselves for reemployment. Protects workers during transfers.
Section 741 is referenced again for the closure notice procedure.
Yes, reiterating the 60-day notice to central government, Form 9, union, and workers via post and email.
Can offenses under the IR Code be compounded? Settled out of court?
Yes, except for offenses punishable only by imprisonment, or imprisonment plus fine. Other offenses can be compounded by a specified gazetted officer on application by the accused before or after prosecution starts.
What's the compounding fee?
50% of the maximum fine for fine-only offenses, 75% of the maximum fine for offenses punishable by up to 1 year imprisonment or with fine, offers a route to resolve less severe issues.
How does one appeal a certifying officer's decision on standing orders?
File electronically with the appellate authority within 60 days of receiving the order. Include a memorandum stating required changes and reasons. Serve a copy to respondents. The authority hears the parties and decides.
And standing orders are maintained electronically.
The finally certified version is sent electronically unless it was deemed certified automatically. Modernizes the process.
The rules also detail the Search Cum Selection Committee, SCSC, for National Industrial Tribunal appointments.
Yes, chaired by a retired judge, includes secretaries from labor and industry ministries, plus an expert. They determine procedure, consider qualifications integrity, and recommend a panel of 2-3 names per post.
How are complaints against judicial members handled?
Preliminary scrutiny by central government, If grounds exist, it's referred to the SCSC for inquiry, within 6 months usually. SCSC submits a report with findings. SCSC isn't bound by Civil Procedure Code, but regulates its own process.
What are the terms of office for tribunal members?
Generally 3 years or until age 65, judicial, or 62, administrative, whichever is earlier, eligible for 1 reappointment.
Salaries and allowances?
Same as Group A officers, level 14 pay matrix. Retired high court judges get salary minus pension. They get LTC, transport allowance like Group A officers, medical fitness declaration needed.
Grounds for removing a judicial member?
Proved misbehavior or incapacity. Informed of charges, opportunity to respond. If removal proposed, referred to a Supreme Court judge for inquiry. Other grounds: insolvency, conviction involving moral turpitude, incapacity, misuse of position. Must take oath, Form 4, before starting.
What's the notice requirement for a lockout? Form 6.
Yes, employer gives notice in Form 6 to the conciliation officer, copy to union and workers, at least 14 days before the lockout starts, allows time for intervention.
How does conciliation work?
Conciliation officer holds proceedings, tries to induce a fair and amicable settlement. If a dismissal case goes to a tribunal and is found unjustified, the tribunal can order reinstatement without back wages or other relief.
What if conciliation fails?
The conciliation officer submits a failure report on the Samvidhan portal within 7 days of concluding proceedings, opens the door for adjudication.
Do employers have to offer jobs back to retrenched workers?
Yes, if they are Indian citizens. When filling vacancies, employers must offer jobs to retrenched workmen via postmail at least 10 days prior. Preference given to those who indicate willingness.
Section 85(2) on authorizing appearance and inquiries.
Authorization needs a certificate, physical or electronic, submitted to the inquiry officer.
And someone wanting to appear for a complainant.
Needs to appear before the inquiry officer and submit a written statement explaining why they're appearing.
What declarations are needed in the retrenchment closure notice?
Details on payment of dues, ongoing insolvency proceedings, and pending court cases related to the establishment. Transparency.
Annexure I requires specific worker details.
Yes, UNNC MPFO number, name, category, joining date, application date, reasons for action. Also requires details of retrenchment terminations in the last 3 years and any other relevant details. Full disclosure.
And objection suggestions on these draft rules were considered.
Yes, the rules state they will be considered before finalization. Stakeholder input.
The rules are titled the Industrial Relations Central Rules 2020 Application.
Whole of India, except for union territories with their own legislatures regarding matters where the central government is the appropriate authority under the code, respects their legislative space.
How can an employee file a grievance against a grievance redressal committee decision?
File with the conciliation officer via Samvidhan portal or post-speed post within 60 days of the decision, or expiry of the 30-day resolution period, can be done by the employee or their union.
And the process for disposing appeals against standing order certifications.
The appellate authority considers grounds, evidence, hears parties, and issues an order. Standard appeal disposal.
Preliminary scrutiny of complaints against tribunal members again.
Yes, central government can set up a committee. If credible, a fact-finding inquiry may follow.
Powers of the officer inquiring into offenses.
Can summon attendance, require document production, impose penalties for offenses committed during the inquiry under specific sections.
Section 89(1) on compounding referenced again.
Correct.
And sections 90 and 91 list matters the central government can make rules and regulations on.
Yes, covering the whole gamut: works committees, conciliation, tribunals, arbitration, standing orders, trade unions, unfair labor practices, penalties, etc. Provides the detailed legislative framework.
Right, well that brings this very extensive deep dive to a close. We've really gone through a massive amount of material.
We certainly have. From the inspector cum facilitator's powers, ESIC fund management, sickness, disablement benefits, gratuity nominations.
All the way to the big codes. Wages, OSH, Social Security, and industrial relations, including their rules and gazettes.
Exactly. The aim, as you said, was to provide a really thorough audio resource to capture all those essential details from the documents you gave us.
Making it accessible, understandable, hopefully a useful alternative to reading hundreds of pages of legal text.
You hope so. Providing that clear, comprehensive overview of India's evolving labor law landscape.
What really stands out, I think, is just the sheer level of detail. The ambition to standardize and regulate almost every facet of the employer-employee relationship.
It's incredibly detailed. For you, the listener, understanding this framework is key to navigating the world of work here. And maybe a final thought to leave with. We've seen the intricate rules, the procedures, the definitions, but The big question is always about implementation, isn't it?
How it plays out in reality.
Precisely. How will these detailed regulations translate onto the factory floor, into the office, across India's incredibly diverse economy? What's the actual practical impact going to be for employers and, crucially, for the workers themselves?
That's definitely something to keep watching, a crucial point to ponder. Well, that's it for this deep dive, custom tailored to give you the comprehensive information you needed. Thanks for joining us. Welcome to the Deep Dive. You know, it really feels like the world of work is just constantly changing, doesn't it?
It absolutely does. Keeping up is a real challenge.
Yeah, and the laws governing it. Well, they shift too. Just when you think you've got a handle on things, the rules change. Today, we're diving deep into a pretty massive overhaul of India's labor laws. The 3 new labor codes.
That's right. We're looking at the Code on Wages, which came out in 2019, and then the Occupational Safety, Health, and Working Conditions Code and the Industrial Relations Code, both from 2020.
Sure.
And what's really interesting, I think, is that these aren't completely new ideas just appearing. It's more like a huge consolidation effort.
So bringing things together.
Exactly. They're merging and trying to modernize a whole stack of older labor laws. Nearly 30 of them, actually.
Wow, 30 laws. Okay, so it's like taking this tangled web and trying to streamline it, hopefully make it more coherent.
That's the goal, yes.
So our mission today, listener, is basically to unpack these codes, figure out what the big changes are and, what they might actually mean for you, whether you're an employee, an employer, maybe just someone interested in how things are changing. We've got a bunch of material here, analyses, government notifications, some academic takes too. So let's jump in. Where should we start? Maybe the Code on Wages 2019. What's the core idea there?
Right. The main purpose of the Code on Wages is really to create one single legal framework for regulating wages and bonus payments across, pretty much all sectors.
All sectors.
Yeah, industries, trades, businesses, manufacturing, even government establishments.
Yeah.
If you think about that consolidation point, this one code essentially merges 4 previous acts that dealt with wages and bonuses.
Okay.
So it's not just about tidying up the administration, it's about trying to get more consistent rules for wages everywhere.
Right, a more level playing field, perhaps, instead of different rules for different places. And I heard this code also massively expands who's covered by minimum wage laws.
Oh, absolutely. The scale is quite striking. Before this code, some of our sources say around maybe 225 million employees were covered. That's about 48% of the workforce.
Okay.
The Code on Wages extends this legal protection to all employees.
All employees, that's huge.
It is. The projection is that maybe another 76 million wage earners will now be covered. Many of these are people in vulnerable situations. Think rural laborers, women, people in tiny businesses.
So it's a big expansion of that basic safety net.
Precisely. It's aiming for a basic level of economic security for a much larger chunk of the workforce.
So who exactly does it cover then? I saw some definitions mentioned.
Yeah, the code tries to provide uniform definitions. An establishment is defined really broadly, basically any place where any industry, trade, business, manufacturing, or occupation happens, including government bodies.
Right.
A worker is anyone except an apprentice doing manual, skilled, technical, operational, clerical, or even supervisory work. And then employee is even broader. It covers anyone employed on wages doing skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, or clerical work.
So very wide definitions.
Very wide. And the definition of employer is also really comprehensive. It includes government, factory managers, whoever's in ultimate control, contractors, even the legal reps of deceased employers. It really tries to pin down accountability.
Okay, cat's a wide net, definitely.
Yeah.
Now, when the code talks about wages, what exactly is included and what's left out?
This is really important. The code is quite specific.
Yeah.
Wages includes your basic pay, dearness allowance, and retaining allowance.
Okay, the core stuff.
Right. But importantly, it excludes quite a few things, like your bonus provident fund contributions, that's EPFO conveyance allowance, HRA, overtime pay, commissions, gratuity, all excluded from this core definition.
Huh. Why is that distinction so important?
Well, if we connect this forward to the Industrial Relations Code, this definition is different from the one in the Old Industrial Disputes Act of 1947.
How so?
The older definition was a bit broader, often included some of those excluded things when calculating compensation if someone was let go.
I see.
So this new, narrower definition in the code on wages, well, it could potentially change how much compensation is calculated in cases of retrenchment or closure later on. The calculation might be based on a smaller base wage now.
Okay, that's definitely something to keep in mind for later. Now, one of the big things I've heard about is this floor wage. Can you break that down for us?
Right, the floor wage. This is a completely new concept in this code. It's basically a national minimum wage level.
A national minimum?
Yes, set by the central government
Right.
based on minimum living standards. They have to consult with the states and the Central Advisory Board on wages to set it.
And how does it relate to existing minimum wages set by states?
Crucially, any minimum wage set by the central or state government cannot be lower than this national floor wage.
Okay.
And if a state's minimum wage is already higher than the floor, they can't reduce it.
So it acts as a baseline everywhere.
Exactly. The hope is this will help pull up average wages across the country and reduce wage inequality. There are even projections suggesting it could significantly lower income disparity, the Gini coefficient measure.
Interesting. So it's not just a number, it's meant to be a foundational safety net.
Yes, and potentially bring more of the informal sector into a more formal structure.
Beyond the floor wage, what about just getting paid on time? Any changes there?
Oh, definitely. The code really emphasizes timely payment. It sets clear deadlines depending on your pay cycle, daily wages at the end of the shift, weekly on the last working day, monthly before the 7th of the next month, and so on.
Makes sensible.
And there's a big push towards digital payments, direct bank transfers, electronic modes. Plus, employers now have to give wage slips, clear records.
Okay. And what about final payments if someone leaves a job?
This is a really interesting bit. If you're terminated, dismissed, retrenched, resigned, or the place closes down, your wages have to be paid within just 2 working days.
2 days. That's fast.
It's a huge reduction from potentially waiting weeks or longer for final settlements.
Wow. Okay. What about deductions from pay? Are there rules around that?
Yes, the code lists specific reasons why an employer can deduct money, things like fines, being absent, cost of accommodation they provide, recovering advances, taxes, stuff like that.
But is there a limit?
Yes, and this is crucial. The total deductions in any pay period cannot be more than 50% of your total wage for that period.
Oh, half your wages, max.
Right. If deductions go over that, they have to recover the rest in later pay periods. It's a safeguard to make sure employees still take home a reasonable amount.
Seems fair. Now, gender equality is always a big topic. How does this code tackle wage discrimination?
This is a positive step. The Code on Wages explicitly forbids discriminating based on gender for wages, recruitment, or working conditions. If men and women are doing the same work or work of a similar nature.
Same work, similar work. Yep.
Okay. And it even sets up a process for an authority to decide disputes about whether work is the same or similar. So there's a legal path to challenge pay gaps.
That's good to hear. What about bonuses? Anything new there?
Yes. The code says all employees earning up to a certain monthly wage, the government will notify the exact amount, and who've worked at least 30 days in a year, are entitled to an annual bonus.
entitled.
Yes. The minimum bonus is either 8.33% of their wages or 100, whichever is more. That's payable regardless of whether the employer made a profit or has an allocable surplus.
Okay, so a guaranteed minimum bonus.
Right. There are also rules about distributing profits as bonuses, but there's a maximum cap too, usually 20% of annual wages. It basically ensures more people get at least a minimum bonus.
Got it. Now, thinking about businesses, especially smaller ones, compliance can be tough. Does this code help them out at all?
Well, that's definitely one of the stated aims to reduce the compliance burden.
How so?
Just merging 4 laws into one is a start, right? Fewer laws to track. And having those uniform definitions for wages, workers, etc. should cut down on confusion.
Makes sense.
They're also trying to streamline things with fewer authorities involved, moving towards a single set of rules instead of like 8 different ones before. And there's a big push for electronic filing, standard templates for registers and returns. Should make it easier to follow the rules.
That sounds like it could actually make a difference. What about inspections? Enforcement? Has that changed?
Yes, there's a bit of a shift in philosophy there. The code introduces the inspector cum facilitator.
Facilitator.
Yeah, the idea is they're not just there to catch people out and penalize them. They're also supposed to provide information and advice to employers on how to actually comply.
So more supportive.
That's the aim. There's also more transparency with web-based inspections, often randomized. And importantly, the inspector has to give the employer a chance to fix any non-compliance before starting prosecution.
Really?
Yes. If the employer corrects the issue, prosecution might be stopped. It's meant to help businesses that make genuine mistakes foster more collaboration.
That sounds like a more constructive approach. But what if they do break the rules deliberately or repeatedly? What about penalties?
Well, the penalties have been standardized and, in many cases, increased. They've introduced graded penalties.
Meaning
The fines get significantly higher, especially for repeat offenses. For example, paying less than the minimum wage, first time, the fine could be up to 50,000 rupees. Do it again within 5 years. You could face jail time up to 3 months or a fine up to 1 lakh rupees, or potentially both.
Okay, so serious consequences for repeat offenders.
Definitely. And they've also empowered certain government officers, like undersecretaries, to hold inquiries and impose fines directly for some offenses, aiming for a quicker resolution. It's meant to be a stronger deterrent.
So a mix of help to comply and stronger penalties. You mentioned the Central Advisory Board earlier. There was a notification back in December 2020 about that.
Yes, that was important. That notification basically activated certain parts of the code on wages related to the Central Advisory Board.
Which parts?
Specifically, the sections dealing with its constitution, some of its functions, and related rulemaking powers. It also brought into force sections dealing with how the board interacts with the Minimum Wages Act concerning the central government. Essentially, it paved the way for the government to actually set up and run this board.
Right, setting the stage. And then we got the detailed rules in 2021. What do those tell us about this board?
Exactly. Those 2021 rules flesh out the details, how it's formed, how it works, who's on it. It's designed as a tripartite body.
Meaning employers, employees,
and independent members, plus government representatives. So you'll have 12 employer reps, 12 employee reps, all nominated by the central government.
Okay.
Then you have independent members. This includes the Labor Minister of State as chairperson, the Labor Secretary, a couple of MPs, some professionals in labor issues, a judge from an industrial tribunal, and 2 chairpersons from state advisory boards rotating in.
A pretty diverse group.
Yes, and the Joint Secretary for Wages is the member secretary. Importantly, the rules also mandate gender diversity. At least a third of the independent members and a third of the total board must be women.
That's good to see. What does this board actually do? What are its functions?
Well, its main job is advising the central government on wage matters covered by the code. But these rules also specifically task it with advising on minimum wages for working journalists and sales promotion employees.
Okay, specific groups too.
Right. The rules also detail how the board operates meetings, quorum requirements. You need at least a third of members, including 1 employer and 1 employee rep, how decisions are made, mostly majority vote, chair gets a casting vote if tied, keeping records. It's all laid out for transparency.
And how long do members serve?
For the non-official members, the employer, employee, and independent reps, it's generally a 2-year term, though they can stay on until a successor is named.
Can they be reappointed?
Yes, they're eligible for renomination, but only up to a maximum of 3 terms in total. So there's scope for continuity, but also fresh perspectives. Official government members serve as long as they hold their government position. The rules also cover things like resignation, removal for non-attendance, and even travel allowances.
Okay, that gives us a really good picture of the code on wages in that advisory board. Let's shift gears now. What about the Occupational Safety, Health, and Working Conditions Code 2020, the OSH code? What's the main aim here?
The OSH code, yeah. This one's got a really broad scope. It's all about consolidating and updating the laws around, well, occupational safety, health, and the conditions people work under in various places.
So safer, healthier workplaces across the board.
That's the idea. It pulls together and modernizes several older laws focusing on these critical aspects.
And who does this one apply to? I remember seeing some numbers.
Generally, it applies to places employing 10 or more workers.
Okay, 10 plus.
But it's even wider for some sectors. Mines and docks are covered even if there's just one worker.
Really?
And importantly, the pulse about health and working conditions apply to all employees. And remember that broad definition of employee we talked about, it covers a huge range of roles.
Right.
Interestingly, it includes contract workers in government offices, but it excludes apprentices, armed forces, and warships. So wide coverage, aiming for baseline standards for most working people.
Okay, pretty extensive reach. Now, a key part of safety is knowing who's doing what, where. What about registration requirements?
Right. Establishments covered by the OSH code need to register electronically. They have 60 days from when the code starts, and they use the Shram Suvita portal.
Online registration.
Yes. They should get a registration certificate within 7 days. And if a business closes, they have 30 days to inform the registering officer and confirm all dues are paid.
Any other requirements?
Licenses.
Some specific types of establishments, factories, mines, places hiring certain workers like beady makers might need additional licenses because of the higher risks involved.
And there's another electronic reporting bit. Employers have to inform the inspector-cum-facilitator within 30 days when work starts and finishes. That info gets automatically shared with the Provident Fund, EPFO, and the state insurance ESIC bodies too.
Streamlining that Social Security reporting as well.
Yeah.
Smart.
Trying to connect the dots, yeah.
So what specific duties does this OSH code put on employers for safety and health?
Several key ones. Employers have a duty to provide a workplace free from hazards that could cause injury or disease.
Basics, right.
Absolutely. They also need to offer free annual health checkups to certain employees, issue formal appointment letters, and report any fatal or serious accidents to the authorities promptly.
And are there extra duties for riskier industries?
Yes. The code lays out additional specific duties for employers in sectors like factories, mines, docks, plantations, construction, tailored to the particular risks in those environments. The primary responsibility for a safe workplace clearly lies with the employer.
And who are these authorities they report accidents to?
Primarily, again, it's the inspector-cum-facilitator. Their role here includes investigating accidents, doing inspections, but also, remember, advising employers on meeting the standards.
Right, the facilitator part again.
Exactly. And beyond them, the code sets up advisory bodies, most notably the National Occupational Safety and Health Advisory Board.
Okay, a national board. What's its role?
The central government sets this up. Its main job is to advise the government on everything related to OSH. That includes proposing standard rules, advising on how to implement the kind, policy issues, research, basically anything the government refers to it.
How long do members serve on this board?
Their term is set at 3 years. It's meant to be the key expert body guiding national policy in this area.
Seems vital for a set of good standards. Are there also requirements for safety structures within workplaces? Committees, maybe?
Yes, absolutely. The code mandates safety committees in certain types of establishments depending on size and risk.
Like where?
For example, any construction project with 500 or more workers needs one. A mine with 100 or more workers. Factories involved in hazardous processes with 250 or more workers.
So larger or riskier places.
Exactly. And these committees have to include representatives from both employers and workers. The idea is collaboration on safety, making sure workers' views are heard.
Makes sense. Get input from the people actually doing the work. What about working hours and overtime under the OSH code?
It sticks to the standard 8-hour day, 6-day week.
Okay.
And it clearly states that if a worker works beyond those hours, they must be paid overtime at twice their regular rate.
Double time.
Yes. And the calculation period for overtime, whether it's daily or weekly, can be set by the relevant government. But the double rate is mandated.
Got it. And keeping track of all this, record-keeping requirements.
Oh, yes. Employers have to maintain registers and records. Details on work done, hours worked, wages paid, overtime hours, leave taken. All needs to be documented, essential for checking compliance.
And I saw something about publishing reports.
Yeah, the government has the power to publish reports from the national board, or any state boards that get set up, or even extracts from other reports received under the code.
Why would they do that?
Could be a way to share information, maybe highlight best practices, or just increase transparency around OSH issues. And like the wages code, both central and state governments can make further rules under this OSH code to fill in the details.
Right, allowing for specifics. Finally, on this OSH code, there was a mention of creches, wasn't there? What's the story there?
Yes, creches. That's an interesting one. The Parliamentary Standing Committee that looked at the code recognized that forcing every small business, every MSME, to set up its own creche could be really expensive.
Yeah, I can imagine.
So they added a provision saying establishments can use common creche facilities set up by the government or even nearby private ones. Or clusters of small industries could pool resources to set up a shared creche.
So options for sharing the burden.
Exactly. The intent seems to be there to support working parents, especially women. But our sources point out that the code doesn't actually specify how these common facilities will be set up or run.
So the how is missing.
Seems like it. The idea is there, but the practical implementation details aren't fully defined in the code itself. That might come in the rules later, perhaps.
Okay, something to watch then. Intent is good, details pending. Let's move to the final piece, the Industrial Relations Code 2020, IR Code. What's the main focus here?
The IR Code is all about the relationship between employers and employees. The big goals are transparency, accountability in how labor laws are enforced, leading hopefully to better industrial relations and boosting productivity.
So smoother employer-employee interactions.
That's the aim, modernizing the whole legal framework around how they interact, how disputes are handled.
And this one also replaces older laws. Which ones?
Yes, another big consolidation. This replaces 3 major old acts. The Trade Unions Act from way back in 1926.
Wow, nearly a century old.
Right. Also, the Industrial Employment Standing Orders Act of 1946, which dealt with conditions of service, and the big one, the Industrial Disputes Act of 1947, which covered dispute resolution.
Okay, so pulling together unions, service conditions, and disputes into one place.
Exactly, trying to create more cohesive structure.
Did this code also change key definitions? We
Yeah.
saw that with the wages code.
Yes, absolutely. Several important tweaks here, too. The definition of industry, for instance, has been narrowed.
How so?
It now explicitly excludes places mainly doing charitable, social, or philanthropic work, sovereign government functions, domestic service, and anything else the government might notify. This is based on an older definition that was actually passed decades ago but never implemented.
Interesting. What else?
We already talked about the change to the wages definition and its potential impact on separation pay.
Wow.
The definition of worker also got an update. The salary threshold for being excluded, like supervisors, was raised from $10,000 to $15,000 a month or whatever the government notifies. So more supervisors might now be covered as workers.
Okay, bringing more people under that umbrella.
And finally, the definition of a strike got expanded slightly. It now includes concerted casual leave taken by 50% or more workers on any given day.
So coordinating taking casual leave counts as a strike now.
If enough people do it, yes. These changes subtly shift who and what the code applies to.
Definitely seems like they could have practical effects. Now, one totally new thing I saw was fixed term employment, or FTE. Can you explain that?
Right, FTE. This is formally defined in the IR code for the first time. It basically means hiring a worker on a written contract for a specific fixed period.
So like a project-based hire?
Could be, yeah. It's now an official category of employment. And crucially, the code says FTE workers must get the same statutory benefits, Social Security, wages, etc., as permanent employees doing similar work.
Parity on benefits. Okay.
And importantly, the code clarifies that if an FTE contract simply expires at the end of the fixed term, that termination is not considered retrenchment.
Okay, so it's not like being laid off.
Correct. The idea is to formalize these kinds of temporary roles and offer some protection.
It sounds like it offers employers more flexibility, maybe for specific projects or seasonal work. What are the potential downsides for workers?
Well, that's the debate, isn't it? On one hand, it could improve conditions for some temporary workers compared to informal contracts, but there are concerns.
Like what?
Well, could it make employers less likely to offer permanent jobs? The code doesn't set any objective criteria for when you can use FTE, no minimum or maximum duration, no limit on using successive FTE contracts for the same job.
I see.
So the worry is that employers might just shift towards using FTE more and more the rules around retrenchment. This could lead to less job security overall, a more precarious workforce.
Yeah, that's a valid concern about potential misuse. Okay, moving on. Trade unions play a big role in industrial relations. How does the code handle union recognition for bargaining?
It introduces this concept of a negotiating union, or a negotiating council.
Okay.
If one single trade union has membership of at least 51% of the workers in a place.
A clear majority.
Right. Then that union becomes the sole negotiating union for collective bargaining.
And if no single union has 51%?
Then a negotiating council is formed. This council includes representatives from all the unions that have at least 20% membership among the workers.
So a coalition approach if there's no majority union.
Exactly. The code also allows the government to make rules about what they negotiate on, how union membership is verified, and what facilities the employer has to provide to the recognized union or council. It aims to clarify who speaks for the workers in bargaining.
Okay, trying to streamline bargaining. Now, what about difficult situations like layoffs, retrenchments, closures?
Yeah.
Any changes to the process there?
Yes, a very significant change. The threshold number of workers an establishment must have before needing prior government permission for closure, retrenchment, or layoff. That's been increased.
Increased. To what?
From 100 workers up to 300 workers.
Wow, triple the size.
Yes. Though it's worth noting some states had already made this change, so this aligns the central law. But essentially, establishments with fewer than 300 workers now have more autonomy to make these decisions without needing government sign-off first.
That's a big shift in autonomy. Does the code offer any support for workers who are affected by these decisions?
Yes, it does. It mandates the creation of a workers' reskilling fund.
Reskilling fund, how does that work?
The relevant government sets it up. Employers who retrench a worker or close down have to contribute an amount equal to 15 days of the worker's last drawn wages into this fund for each affected worker.
Okay, a contribution based on wages.
Right. And the idea is that this money has to be used within 45 days of the retrenchment, specifically for reskilling that worker. The exact mechanisms are still to be detailed in rules, but the principle is there supporting workers to transition.
That sounds like a potentially valuable cushion and support mechanism.
Yeah.
What about actually resolving disputes? How have the mechanisms changed?
There's been a move to simplify the structure. The old system had various bodies, courts of inquiry, boards of conciliation, labor courts. The IR code pushes towards making industrial tribunals the main adjudicating bodies.
Fewer bodies, more focus.
That seems to be the idea. And crucially, the old requirement for the government to formally refer a dispute to a court or tribunal for it to be heard, that's gone, except for the national tribunal level.
So potentially easier access to the tribunal.
Potentially, yes. And the tribunals themselves are proposed to be strengthened with 2 member benches, 1 judicial member, 1 administrative, maybe to handle cases faster. Their jurisdiction is also expanded to cover disputes involving registered trade unions themselves. Aims for efficiency.
So faster, more streamlined dispute resolution. What about smaller issues, minor violations? How are those handled?
The code allows certain government officers under secretary level or equivalent to impose fines directly for offenses where the only punishment is a monetary fine.
Skipping the courts for fines.
For certain offenses, yes. They can hold an inquiry, hear the parties, and impose the fine. The goal is to reduce the burden on the tribunals and courts for less serious matters, get quicker resolutions.
Sounds logical. Would free up the courts. What about penalties for more serious breaches under this code? Are they also rationalized?
Yes, similar to the other codes, penalties are meant to be more proportionate. But for serious violations like ignoring the rules on layoff, retrenchment, or closure procedures, the fines are substantial.
Like how substantial?
For a first offense in those areas, the fine could range from 1 lakh up to 10 lakh rupees, and repeat offenses can attract even higher fines, potentially imprisonment as well. So a clear message against major violations impacting workers significantly.
Definitely higher stakes. I also saw a term compounding of offenses. What's that about?
Compounding is basically a way to settle certain offenses without a full prosecution, specifically those that don't carry a potential jail sentence.
How does it work?
An accused person can apply to a designated gazetted officer. If approved, they can settle the matter by paying 50% of the maximum fine prescribed for that offense. This can happen before or even after prosecution has started.
So a settlement option. Are there limits?
Yes. You can't compound an offense if you've done the same thing within the last 5 years or if you've been previously convicted for it. And if you agree to compound but then don't pay up, you could face an additional penalty. It's a way to resolve simpler cases efficiently, but with safeguards against abuse.
Okay, an efficiency measure with checks. So pulling back a bit, what are some of the overall potential implications or concerns that our sources highlighted about this industrial relations code specifically?
Well, a few things come up. There's a concern that having different definitions for employee and worker might actually leave some people out of the dispute resolution process. Scheme workers, like Anganwadi workers, are a large group often seen as neglected by this code too. And excluding charitable or philanthropic institutions from the industry definition, some worry this could actually worsen conditions for people working there.
Right, removing protections?
Possibly. On strikes, while extending the 14-day notice period to all sectors might help conciliation efforts.
Yes.
There are still those worries about fixed-term employment potentially eroding job security, as we discussed.
And if FTE concerns again?
Yes. And the code doesn't really tackle the long-standing issue of having lots of small, competing trade unions. Some analyses fear the whole trade union movement could be weakened further by things like the lack of a deadline for registration and that potentially high 51% threshold for becoming the sole negotiating union.
So potential weakening of worker bargaining power.
That's a key concern raised, yes. These are important perspectives to keep in mind as this code gets rolled out.
Absolutely. So it's definitely a complex picture. Modernization and flexibility aims, but also real concerns about the impact on workers' rights and security.
It is complex. Taken together, these 3 labor codes, they really do represent a fundamental reshaping of India's labor law landscape. That goal of consolidation, modernization, trying to balance employer and employee interests, it's clear across all 3.
Yeah.
But as we've seen today, the potential impacts are really varied, and they'll definitely continue to be watched and debated as implementation moves forward.
No doubt. Well, this deep dive has hopefully given you, our listener, a solid grounding in these really significant legal changes. We've covered a lot: wages, safety, industrial relations. We definitely encourage you to maybe explore the specific bits of the codes or the rules that come out that matter most to your own work life or business. There are government resources and more detailed analyses out there.
Absolutely.
And as you think about all this, maybe consider, how will these evolving laws continue to shape the future of work here in India? And, what role might you play in that changing picture? Thanks for joining us on The Deep Dive. You know that feeling. You need to get your head around something really important, but there's just this mountain of documents, and it feels, well, impossible to scale. That's exactly why we're here. Welcome to The Deep Dive, the place where we pull out the vital knowledge you need without completely burying you in information overload.
And today, our job is, well, it's pretty clear-cut, but also quite comprehensive. We've got this collection of really essential documents in front of us.
Right.
There are the draft rules for the Code on Occupational Safety, Health and Working Conditions, the OSH Code from 2020. Plus, we've got related bits and pieces covering Social Security, wages, industrial relations, and some key compliance stuff.
Okay.
Our mission really is to go through these meticulously. We want to draw out every single key detail they contain.
Think of this as like your audio blueprint for these documents.
Right.
We're not just scratching the surface here, we're going deep, pulling out all the relevant info in a hopefully clear and structured way. Almost like you're reading the originals yourself, but, without the headache.
Yeah.
And our absolute top priority is making this information accessible. We're translating what can be pretty dense legal language into straightforward, universally understandable English. It's tailored specifically for you, the learner, whatever your background.
Precisely. We're aiming for a structured journey through this material, something easy to digest. We'll flag the key aspects, try to clear up any potentially confusing areas, and make sure that by the end, you've got a really solid handle on the essential information locked inside these documents. So yeah, let's dive in.
Okay, let's unpack this. First off, it's important to remember these are draft rules for the OSH code we're looking at.
Yep.
That means they were open to feedback, right?
Absolutely. The document explicitly mentions an invitation for objections and suggestions. It really highlights that making these regulations is often, an iterative process. They're looking for input from the people who will actually be affected.
And it wasn't just a free-for-all comment section, was it? I noticed something about a specific format.
You're right. And that's fascinating, actually. It wasn't enough to just say, I don't like this rule. They required a very detailed format.
Like what?
You had to give your name and address, clearly identify the specific rule or sub-rule you wanted changed, state the exact wording of your proposed amendment, and this is key, give the reasons why you were suggesting it.
So you have to build a case, essentially.
Exactly. It ensures the feedback is precise, actionable, and importantly, backed by some rationale. It makes the feedback much more likely to have an impact.
And people didn't have forever to do this, did they? There was a deadline mentioned.
Correct. A 45-day deadline, starting from the date these draft rules were officially published. It just emphasizes you need to be timely if you want to engage with these regulatory processes. Gives you a sense of the typical time frame, too.
Okay. So moving into the actual content of the draft rules, what about something like driving time? Any specifics there?
Yeah, it's interesting. For anyone operating a transport vehicle, these draft rules laid out a maximum permissible break of just 15 minutes at any one time during their driving period.
Only 15 minutes. Wow, that seems short. You might think longer breaks would be encouraged for safety.
It is a notable detail, isn't it? It could have pretty significant implications for transport and logistics folks. It makes you wonder about the thinking behind that specific number.
Yeah, maybe balancing rest with delivery schedules or something.
Possibly. Now, here's where it gets really interesting, I think, looking at working hours. The draft rules say they do apply to working journalists, but there's a big initial exclusion.
Ooh, who's excluded?
Editors, correspondents, reporters, and news photographers are initially carved out from these specific working hour provisions.
They're surprising. Those are often the roles you think of with really demanding schedules in journalism.
Exactly. It seems a bit counterintuitive at first glance.
So who would this section on working hours primarily apply to within journalism then? More office-based staff, admin roles perhaps?
Well, while those specific roles, editors, reporters, etc., are excluded from that particular section on working hours for journalists, it's really crucial to understand something else.
Okay.
Other sections and general provisions within these draft rules do still apply to every correspondent, reporter, or news photographer. Things like general safety rules, other employment conditions, we'll definitely touch on those as we go.
Okay. So it's not a total exclusion from all rules, just that specific bit on journalist working hours. Got it. Now, what about when someone's been off sick? There's something about fitness certificates.
Yes, that's pretty standard practice, it seems. For both working journalists and sales promotion employees, if they've taken sick leave, these drafts say they must submit a fitness certificate from a competent doctor or medical officer before they can come back to work.
Makes sense. Ensures they're actually fit to return, protects everyone.
Exactly. It underscores verifying fitness after illness.
But who counts as a competent doctor or qualified medical officer? Does the company just pick anyone?
No, the rules say every place employing working journalists or sales promotion folks must designate one or more qualified medical practitioners, and that designation has to follow Section 42 of the Code, which likely sets out the specific qualifications needed. Ensures a recognized standard.
Okay, let's switch gears to time off. Earned leave. How does that work for these groups?
For working journalists and sales promotion employees, the draft says they earn leave for every 11 months they spend on duty. So it establishes a clear accrual rate.
11 months on duty for how much leave? Does it specify the amount earned?
The text just states they earn leave for every 11 months on duty. The specific amount of leave earned per 11 months might be detailed elsewhere in the code or potentially in employment agreements, but this rule establishes the qualifying period.
Gotcha. Now, I saw something about compensatory leave, especially for work that can't be stopped. like for technical reasons.
Right. Workers doing jobs that genuinely can't be interrupted continuously for technical reasons. They're treated as an exception regarding the usual compensatory leave rules.
And for everyone else.
For others, where compensatory leave is allowed under Section 26(3) of the Code, the rules say it should be given so that you don't get more than 2 compensatory days off in a single week. Probably to avoid disrupting operations too much.
Okay, and who sorts out scheduling this compensatory time off?
That falls to the establishment manager. They have to decide and officially let the worker know about the compensatory leave for any lost work days.
When do they have to do that?
Either within or before the end of the month the work days were missed, or, at the latest, during the following month. Keeps it reasonably timely.
Let's talk overtime. Always a big topic. Are there exceptions to the general limits on overtime hours?
Yes. While there's a general cap, 125 overtime hours in any quarter of a year, these draft rules list specific types of workers who are exempt from that limit.
Who falls into that category?
It includes people working on processes held up by machinery breakdowns, workers loading or unloading railway wagons, lorries, or trucks. You can imagine the time pressures there.
Right, logistic.
Exactly. Also, workers facing exceptional pressure of work that sounds a bit subjective, but it's in there. And finally, anyone doing work that the central government officially declares via the Gazette to be of national importance.
So emergencies, critical logistics, national interest type stuff. Makes sense to have flexibility there.
Seems to be the logic, yes. To ensure essential operations aren't hindered.
Moving on to more admin things. There's a brief mention of maintaining registers, records, and returns. Standard compliance stuff.
Pretty much fundamental, yes. Ensures transparency, allows monitoring of conditions, wages, all that. The rule itself is short, but the details of what records, what format, that's usually in the accompanying schedules and forms.
Okay. Then there's the Board of Vocational Training. What powers does this board have?
It can set up advisory committees. More importantly, especially for mining, it has the authority to specify the standards mine owners have to meet when setting up their own independent vocational training centers.
Why mandatory centers for mines?
The main goal is to ensure uniform, high standards for training people working in mines. Given the safety risks involved in mining, that uniformity is pretty critical.
Absolutely. Specialized skills, high stakes. Now, the documents mention specific forms for mine info. Tables A, B, and C. What are they tracking?
They're designed to capture really detailed operational data. Table A is just for coal mines.
What kind of details?
Things like how much mineral was produced, opening and closing stock levels, coal excavated, coal dispatched, any coal used internally, the value of what was produced, and even how much waste rock or debris was handled. A real snapshot.
Very thorough for coal. What about Table B for metalliferous mines? Similar idea.
Similar concept, yes, but tailored. It tracks mineral raise, stock levels, output, dispatches, how much metal was actually extracted from the ore, the value, and the total material handled, distinguishing between the raw ore and the processed stuff.
And Table C changes focus completely.
Right. Table C is all about the machinery used in both underground and open cast mines.
What kind of machinery detail?
It breaks it down by function cutting, drilling, loading machines, compressors, conveyors, pumps, ventilators, processing plants, and an other category. And for each type, it asks for the quantity and the total horsepower. Gives a clear picture of the mine's equipment, inventory, and power.
That's incredibly detailed insight into mine operations.
Let's shift to inspections. If an inspector-cum-facilitator finds violations, but isn't happy with the company's first attempt to fix things, what happens?
If they're not satisfied with the corrective measures taken, they can issue a formal order. And importantly, issuing that order doesn't stop them from taking further legal action later if needed.
So it's potentially a step towards more serious enforcement.
Exactly. It shows a multi-layered approach. Fix it, but if you don't fix it well enough, there are more consequences.
The documents also mention reinspection. When would that happen?
It's specifically mentioned for places using certain equipment, lifting gear, transport equipment, ladders, scaffolding, that sort of thing. They'll get re-inspected once they notify the authorities that they've complied with the initial findings. So the re-inspection is to verify the fix.
Precisely. To make sure the reported actions were actually effective and the place is now compliant.
And how do they know when the re-inspection is coming?
They'd receive a contravention notice. It formally states the date in place for the reinspection. This happens after the establishment says they've sorted out the problems initially flagged.
It really underlines the need to not just find problems, but follow through on fixing them properly. Okay, let's pivot to a specific group. Audio-visual workers. What rights do they have under these rules?
Well, one significant right is recognition. They have the right to have their name in the film's credit titles. And interestingly, they can choose whether or not to permit their name to be used. Gives them some control.
That's important in creative fields. What about their appearance on screen, costume, makeup? Do they get a say?
The producer generally decides how the worker's personality is represented: clothes, makeup, hair. But there's a condition.
Yeah.
The producer has to inform the worker about these requirements and get their agreement. So it tries to balance the creative vision with the worker's comfort.
And what are the basic obligations of the audiovisual worker in return?
Pretty standard professional stuff, really. They agree to provide their services to the best of their ability, follow directions from the producer or director, and comply with all reasonable instructions for making the film.
Okay, we talked about notifications for the initial draft rules. Are there other important notifications the public should know about?
Yes, generally, any subsequent draft notifications about different aspects of these regulations are also made public. It keeps the process transparent and allows more chances for feedback on specific points before they're finalized.
And if someone wants to comment on those later drafts, is the process the same? Same context?
The documents give specific contacts for later drafts, mentions a Sri Shivakant Kumar, and provides email addresses: fastly at dgfetisi.slenik.in and shivkant.kr@gov.in. The basic format requirements for feedback stay the same, though. Keeps it standardized.
Got it. Now let's talk about when things go seriously wrong. There's a section on notice of dangerous occurrences. What triggers this reporting?
If a dangerous occurrence, and there's a schedule defining what counts happens at a workplace, a notice in Form 6 has to be sent electronically
To whom and when?
to the inspector-cum-facilitator and the district magistrate or subdivisional officer. It has to be sent within 12 hours after completing 48 hours following the occurrence.
Okay, that timing is specific. Does it matter if anyone got hurt?
No, that's the key point. This reporting is required regardless of whether anyone suffered bodily injury or disability. Certain events are just considered inherently dangerous and need reporting because of their potential.
So the potential risk itself triggers the need to report. What if, tragically, someone dies because of an accident or one of these dangerous occurrences?
The procedure is even more urgent then. Immediate telephonic notification is required, followed by submitting Form 6 within 12 hours.
To the same people.
Yes, to the inspector-cum-facilitator, the district magistrate or subdivisional officer, and also to the immediate relatives of the person who died. It underscores the seriousness and the need for prompt official awareness.
Absolutely. What kind of events actually count as these dangerous occurrences needing immediate reporting?
The rules list examples. Things like specific types of explosions, significant fires, building collapses, serious damage to rooms where people work, boiler or pressure vessel explosions, lifting machinery failures, and accidental contact with live electrical wires. High-risk stuff.
Definitely sounds like major incidents with potential for serious harm. Now, what about the employees themselves? What are their responsibilities for safety?
Employees have a really crucial duty here. They need to report any unsafe or unhealthy condition they notice in the workplace.
As soon as possible.
Yes, as soon as is practicable. They can report it to the employer, the health and safety rep, the safety officer, or the agent or manager in a mine, and they can do it electronically, in writing, or even just by phone. Multiple ways to raise concerns.
So they're expected to be active participants in safety. The documents also mention safety committees. What do they do?
They're key bodies for workplace safety. Their main jobs are discussing reports on safety, environment, health surveys, reviewing audits and risk assessments, looking into things likely to cause danger and suggesting fixes, and checking if previous safety recommendations have actually been implemented effectively.
Who usually chairs these committees, particularly in mines?
In mines, the rules say the mine manager, the one referred to in Section 67 of the Code, is the ex officio chairperson. Put someone with direct operational responsibility in charge of safety discussions.
Okay, let's circle back to working hours for a second. How are rest breaks treated when calculating total work hours?
Generally, rest intervals aren't counted as duty hours, but there's a limit.
What's the limit?
The total time for rest breaks shouldn't exceed 2 hours in a workday. If it goes over 2 hours, the extra rest time is counted as duty time.
So, a cap on excluded break time. What about extra hours worked in mines? How is that compensated?
For mine workers, any work over 36 hours in a week, that's the unit they use, has to be compensated with rest in the following week.
How much rest?
It should be given in spells of at least 3 continuous hours each. But if the extra work was less than 3 hours, the rest is just limited to that amount of excess time worked.
Interesting way to handle it, focusing on providing rest periods soon after. We touched on working journalist hours earlier, but let's get the exact details from the rules.
Right. The normal working day for a working journalist is specified as not more than 6 hours for a day shift and 5.5 hours for a night shift. And importantly, that excludes meal times.
And they shouldn't be asked to work longer than that.
The rule says they should ordinarily not be required or allowed to work longer than those normal hours.
Okay, now what about earned leave that hasn't been used? If a working journalist or sales promotion employee leaves their job, do they get paid for that unused leave?
Yes, they do. If their employment ends for any reason except disciplinary action, they're entitled to cash compensation for unused earned leave.
Is there a limit?
Yes, it's capped at a maximum of 90 days of earned leave.
And how much money do they get? Is it based on their salary when they started?
No, it has to be calculated based on their current rate of wages at the time their employment ends. It shouldn't be less than the wages they would have received if they'd actually taken that leave. Ensures fair compensation.
That's a good safeguard. What about job security while they're on paid leave? Can they be fired then?
No, the rules explicitly protect working journalists and sales promotion employees from being discharged or dismissed while they're on any leave with full wages.
And does that leave period count towards any notice period they might have to serve?
No, it doesn't. The leave period cannot be counted as part of any required notice period for discharge or dismissal. Protects their ability to actually take leave without penalty.
Okay, let's just quickly revisit the general rule for overtime pay for most workers.
Sure. The standard rule for most workers is if you work more than 8 hours a day or 48 hours a week, you get paid wages at double your ordinary rate for that overtime work. And that extra pay should be given at the end of each wage period.
Got it. Back to inspections. What powers do inspector-cum-facilitators have to collect evidence during a visit?
They're allowed to take samples of articles or substances found in the workplace.
Can they just grab anything?
Well, it has to be done according to the inspection scheme on the Shram Suvita portal. And importantly, they have to inform the employer first and follow the proper procedure for collecting and handling the samples. Allows for lab analysis if needed.
We keep mentioning qualified medical practitioners. What exactly makes a doctor qualified under these rules?
There are specific criteria. They need a recognized medical qualification under the Indian Medical Council Act 1956, and they must be enrolled on both the Indian Medical Register and the relevant state medical register. Ensures proper training and registration.
So, formal education plus official registration. What are the duties of these medical officers when they're asked to do an exam under Section 42?
They have a clear process to follow. First, give prior notice to the person about the exam date, time, and place. Second, conduct the examination. Third, prepare the certificate of age and fitness in the specified format, Form 4. And fourth, send that completed certificate to the employer who requested the exam.
Sounds straightforward. Are there broader rules about medical exams in general for workplaces?
Yes, the first schedule of the code details rules for medical supervision in places with known chronic occupational illnesses, or where the work itself poses health risks. It also covers undertaking occupational health surveys to proactively identify hazards.
Okay, let's shift to contract labor. Getting a license often involves fees. How are those calculated?
There's a fee structure, yes, and it scales based on the number of contract laborers the contractor plans to employ.
So more workers means a higher fee.
Exactly. It starts at, I think, $2,000 for up to 50 workers and goes up in tiers. The highest mentioned is $40,000 for over 20,001 workers. Likely reflects the admin effort of overseeing larger operations.
And renewing these licenses. Is it complex?
It's meant to be streamlined. Contractors apply for renewal electronically through the Shram Suvita portal.
What about the conditions for contract workers themselves? Wages, holidays, working hours, are they supposed to be the same as direct employees?
That's a key point. The draft rules state that wage rates, holidays, hours, and service conditions should be equivalent to directly employed workers doing the same or similar work in that establishment.
What if there's a disagreement about whether the work is similar?
That dispute can be referred to the inspector-cum-facilitator, and their decision on that specific point is final. For other aspects, conditions are as per the code and rules. And crucially, all contract labor must be enrolled in EPFO and ESIC where applicable. Aims for parity in Social Security.
That's important for fairness. But what if a contractor doesn't follow the rules? Can they lose their license?
Yes, definitely. The licensing authority can suspend the license for non-compliance. But first, they have to issue a show cause notice, giving the contractor a chance to explain.
Can the suspension be lifted?
It can, yes. If the contractor fixes the problem within the given time and provides a satisfactory explanation, the suspension can be revoked with a written order.
And if they don't comply?
Then the authority can move to revoke the license immediately, again with a written order stating the reasons, and they notify the contractor and labor authorities electronically.
Okay, clear process there. What about workers who move between states for jobs, interstate migrants? Is there help with travel costs if they change employers?
Yes, there's a provision for a journey allowance. If an interstate migrant worker changes jobs and didn't get the allowance from their previous employer, the new employer has to pay it.
Under condition.
Yes, the worker needs to provide a certificate saying they didn't receive it before, and they must have completed at least 180 days of employment in the last 12 months, and that can include time with the previous employer. Helps ensure they're not out of pocket for job transitions.
Good protection. Now, back to mining manager certificates of competency. These sound like serious qualifications.
They are very critical, reflecting the high responsibility. The requirements are quite detailed and vary.
How do they vary?
For instance, for a first-class manager's certificate for coal mines, the criteria depend on the mine's average annual output, whether it's underground or open cast, even if parts are restricted. There are similar detailed rules for second-class coal certs, and also for first and second-class certs in metalliferous mines based on output or material handled. There's even one just for open cast metal mines. It's tiered to match the mine's scale and type.
So a very granular system. Are there any mines that don't need a manager with one of these certificates?
Yes, some smaller, simpler operations are exempt. Generally, small surface workings for things like gravel, ordinary sand, clay, building stone, road metal, if the work doesn't go below the natural ground level, or if it's open cast and less than 6 meters deep. Lower complexity, lower risk, presumably.
Makes sense. Who does the mandatory medical exams for mine workers? Need specialist knowledge, right?
Absolutely. The exams have to be done by a qualified medical practitioner, either employed by the mine owner or assigned by them, or it could be a government medical officer. Crucially, whoever does it must have specific training in occupational health, including the ILO system for classifying chest x-rays, and that training needs central government recognition. Ensures they know what mining-related health risks to look for.
Specialized expertise is key. How are these exams actually arranged? What's the notice procedure?
For initial exams, the owner, agent, or manager has to give formal notice using a specific form to both the worker and the examining authority, and it has to be at least 10 days in advance.
What if someone misses the appointment for a good reason?
They get a second notice, again with at least 10 days warning. The manager sends copies of these notices to the examining authority. And once the exam happens, the authority informs the manager.
And if someone is found medically unfit after the exam, what happens to their job?
If declared medically unfit, they can't be employed or continue to be employed in that mine or category of mine or operation after 30 days from the exam date.
Unless
Unless they file an appeal. If they appeal, the restriction is paused, but if the appellate medical board also declares them unfit after re-examination, then the restriction kicks in.
Okay, let's switch to mine safety protocols and emergency response. What are the key duties of a mine superintendent?
They have several critical roles. Ensuring rescue apparatus and all related gear is always available and in perfect working order. Maintaining and countersigning safety records, making sure people get the proper initial and refresher training and their certificates, and periodically inspecting the mine's rescue rooms and equipment. Keeping everything ready.
Can a superintendent take action against rescue team members if needed?
Yes. If they find deficiencies or breaches of duty, they can suspend or even permanently debar a team member from rescue work. But importantly, only after giving the person a chance to provide a written explanation. Fair process first.
And if there's an actual emergency needing a rescue team, what's the immediate protocol for the manager or senior official?
As soon as they get word, the manager, or the most senior official present at the surface if the manager isn't there, has to act immediately. Inform the rescue room or stations serving the mine, request assistance, and summon all mine personnel who have rescue training. Speed is critical.
Makes sense. What about the rescue team members themselves during an operation? Any specific rules for them?
Yes, clear guidelines. Strictly obey the team leader's orders. Check your own breathing apparatus before entering. Stay in your designated position in the team, and immediately tell the leader if the pace is too fast or if you feel any distress. All about safety and team effectiveness.
There's also a rule about a second spell of work in bad air An irrespirable atmosphere. What's that about?
It's a strict safety measure. A person cannot start a second work spell in an irrespirable atmosphere unless they've just had a medical exam by a qualified practitioner and been certified fit specifically for that immediate spell of work. Prevents overexposure and health risks from repeated exposure without clearance.
Training is clearly vital in mining. What are the basic requirements for mine training schemes?
Every single mine must have a training scheme, and it needs to be formally approved by the chief inspector cum facilitator of mines. And the authorities can demand changes if they think the scheme isn't adequate.
What absolutely has to be in these training schemes?
3 core things, minimum. Provisions for initial training for all new hires, refresher training programs to keep existing workers' skills and knowledge current, and specific training whenever new technology, new equipment, or significantly different work procedures are introduced. Covers all bases, new people, existing skills, and adapting to change.
Right. Back to the Board of Vocational Training. How often do they meet and what are the procedures?
They have to meet at least once every 3 months. Regular meetings need 21 days notice. The chairperson sets the agenda. For a valid meeting, you need a quorum, at least 1/3 of the members, including at least 2 from each category represented on the board.
How are decisions made?
Usually by majority vote of those present and voting. If there's a tie, the chairperson gets a casting vote. They can also circulate urgent matters for opinions, but the chair can decide to hold it for a formal meeting discussion.
And how are the meeting records kept and confirmed?
The secretary records the minutes in a proper minute book. Draft minutes get circulated to members who attended.
For review.
Exactly. Then, at the next meeting, the minutes are presented for confirmation. Once confirmed, the chairperson of that meeting signs them. A certified copy then goes to the central government within 15 days, and members can inspect the minute books free of charge.
What are the main jobs or functions of this board? What does it actually do?
It does quite a lot related to vocational training quality, prepares training syllabi, arranges training programs, conducts exams, awards certificates. It establishes model training centers as benchmarks, assesses ongoing training needs and performance, sets criteria for common training centers, prescribes application fees for center approval, and sets guidelines for paying instructors and trainers. Really oversees the whole vocational training ecosystem.
Okay. Shifting again, what about inquiries into mine accidents or dangerous occurrences? How does that work?
If an inquiry is needed, the central government appoints a competent person to conduct it. That person's job is to impartially investigate what happened, find the causes, and identify anyone they believe was responsible based on the evidence.
What needs to be in the final inquiry report?
It needs clear findings on the causes, both immediate and underlying. It has to name the individuals believed responsible, and crucially, it must include practical, actionable recommendations to prevent similar things from happening again. Specific enough to be implemented. For dock work accidents, they might appoint someone specifically qualified in that area.
Once an inquiry is set up, how are people notified and involved?
Notices are served following specific procedures. If someone applied for the inquiry, they definitely get notified. The exact procedure during the inquiry is up to the competent person conducting it, and they have to outline it at the start of the hearing, considering any initial points raised by attendees. They'll also mention any planned site visits.
Who actually gets to attend and participate in these inquiries?
Several groups have the right to be there. The competent person, any relevant enforcing authority, employers associations, trade unions representing involved employees, anyone injured or who suffered damage, or the representative, and anyone else who can show a legitimate interest with the permission of the competent person.
Right. Now, these documents are full of references to forms. We've mentioned a few. Can we quickly recap some of the key ones and their purpose?
Sure. Form 1 is the application for a contract labor license. Form 2 is the certificate of registration for establishments using contract labor. Form 3 is for reporting a dangerous occurrence. Form 4 is that very detailed medical examination fitness certificate. We discussed history, exams, tests, fitness for specific jobs, final report.
What about reporting an actual accident?
That's Form V, the notice of accident or dangerous occurrence. Captures details of the injured person, the place, time, cause, machinery involved, what was happening at the time.
And some key compliance forms.
Form X is the big annual return unified across codes, needs tons of detail on the establishment, workers, all types, gender, PWD, contractors, welfare amenities, leave, wages, accidents, plus specific mine tables. Form X is the register of accidents, dangerous occurrences the company keeps. Form A-11 is the contravention requirements notice from inspectors, and Form 8 is the half-yearly return for the building and construction workers, cess project cost, cess paid, etc.
Definitely a lot of detailed record keeping involved. Back to audiovisual workers, how can their agreements be terminated by a producer?
A producer can terminate for reasons like non-performance or unwillingness to perform, but only after paying all outstanding dues calculated based on work done versus work contracted. And crucially, this can only happen after the producer's claims have been substantiated before a special forum.
What is this forum?
It's set up specifically for these disputes. Equal representation from the producer's organization and the workers' organization. Its decision is binding on both sides. Only after the forum decides can the producer hire someone else for that job. Provides an industry-specific resolution path.
Okay. Now, thinking about medical benefits provided by establishments, what do the rules say about the specifics, medicines, staff, equipment?
The rules indicate that the details, the exact nature and amount of medicines, the number and qualifications of staff, the types of equipment will be laid out in subsequent regulations. The goal is to ensure a consistent, desired standard of care.
Is there a standard list of medicines they should have?
Yes, a medical formulary will be established. It will list the specific medicines to be used for the medical benefits provided under these rules. Standardizes supplies.
And the paperwork side of medical benefits, certifications, records, reports.
Procedures and standard forms will be prescribed for medical certification, statistical returns, registers, and other necessary medical records. Ensures consistency in documentation.
What about broader measures to improve worker health and welfare?
The rules highlight measures like medical treatment and care, but also specifically mention rehabilitation for those who become disabled or infirm due to work. Shows a focus beyond just immediate treatment towards long-term well-being.
And any rules on the conduct of the doctors providing these benefits?
Yes, the rules state that the professional conduct of medical practitioners employed for providing these benefits will also be governed by specific guidelines. Ensures ethical and professional standards.
Let's look at the Social Security bodies now. The Standing Committee was the term of office for its members?
For regular members, not ex officio ones, it's 4 years, starting from when their appointment is notified. But they stay on until their successor is notified, ensuring continuity. Also, if a standing committee member later becomes a member of the main federation, their term on the standing committee ends automatically.
What if a spot opens at midterm on the standing committee?
A casual vacancy can be filled by nomination. The person nominated serves for the rest of the original member's term, keeps the committee fully staffed.
The National Social Security Board for Unorganized Workers. How can a member be removed?
If removal proceedings are started under certain rules, the member might be temporarily kept from attending meetings while it's pending. But the final decision on removal, disqualification, or accepting a resignation rests solely with the central government. Their decision is final.
What other jobs does this board have besides advising?
It's actively involved in specific welfare measures. Things like framing group insurance schemes, maybe helping with premiums, creating educational schemes for workers' children, and providing financial help for major medical expenses for beneficiaries or their dependents, more hands-on than just advising.
Is there a way for the central government to create new welfare schemes just for building workers if needed in certain areas?
Yes. If the central government thinks it's necessary to improve building workers' welfare in specific states, it can create new schemes or add provisions to existing ones through official notifications. Allows for tailored responses.
How often do these various social security organizations and committees have to meet? And what about procedures and allowances?
The specific intervals, meeting procedures, and fee allowance rates are generally as prescribed in the relevant code sections and rules. But typically you'd expect reasonable notice, like 21 days, chair presides, quorum needed, majority vote, minutes kept and confirmed. Standard governance practices.
Okay, let's talk tribunals and legal processes. Can a tribunal cancel a hearing that happened without one party present an ex parte hearing?
Yes, it can under certain conditions. The respondent, the party who wasn't there, has to show they had a sufficient genuine reason for not attending. The tribunal also needs to be satisfied that the order can be set aside just for that respondent without harming others, and that it's possible to basically restart the case against them. There are exceptions, though, if the order inherently involves multiple people, or if the absence was due to not getting the notice in the first place.
Once the tribunal makes an order, who makes sure it's carried out?
The registrar of the tribunal is responsible for issuing the orders under the presiding officer's direction and handling other administrative tasks assigned by the presiding officer.
What about the official seal of the tribunal? What does it look like?
It's described as circular. The tribunal's name is around the edge in capitals, and the Ashoka pillar emblem is in the center. Signifies its official authority.
Who controls the use of the seal?
The registrar is the custodian, but the seal can't be put on any order, summons, or process unless the presiding officer gives specific written authorization for that instance. Same for certifying copies. Ensures proper judicial oversight.
Let's look at the corporation's finances. What counts as administrative expenses?
It covers a lot of operational costs, fees and allowances for corporation and committee members, salaries, benefits, leave pay, travel, bonus, gratuity, pension contributions, training costs for staff, office expenses like rent, maintenance, vehicles, legal fees, audit fees, and any other necessary spending approved by the standing committee or the corporation itself, basically the costs of running the organization.
Now, maternity benefits eligibility. What are the absolute key requirements for an insured woman?
She needs to have worked for at least 80 days in the 12 months right before her expected delivery date. And that 80 days includes days absent due to a legal strike or lockout. Ensures a reasonable recent work history.
How long is the benefit paid and at what rate?
It's paid for the whole maternity leave period allowed under the code. The rate is her average daily wage just before the leave started. This applies for confinement, miscarriage, medical termination, or illness arising from these. She might need to provide medical evidence as per the regulations too.
What about permanent disablement benefits? How does that work?
Someone with permanent disablement, total or partial from a work injury, gets periodic payments. It doesn't matter if the disability was assessed provisionally or finally.
How long are the payments for?
If provisional, for the limited period of the assessment. If final, for life. The daily rate is calculated as 90% of the standard benefit rate applicable at the time of the injury, rounded up.
And if an insured person dies from a work injury, how is the dependents' benefit distributed?
There's a clear allocation. A widow gets a lifelong pension 3/5 of the full rate. A widowed mother gets the same 3/5 lifelong. Each orphan child gets 2/5 of the full rate until age 25, longer if they're infirm and can't earn. Other dependent parents or grandparents get 3/10 lifelong, split equally if there's more than one. Other dependents might get something as determined by the corporation. Proof of age and dependency is needed, of course.
What about medical benefits when someone first becomes insured? Is there an initial waiting period?
They get medical benefit for an initial 3 months right after becoming insured, but there's a condition. They need to remain an employee of a covered establishment for 3 months or more leading up to the start of the relevant benefit period. Ensures some minimum contribution association period.
The rules mention different types of banks. Can you quickly clarify nationalized bank, scheduled bank, and bank authorized for government agency business?
Sure. Nationalized bank refers to specific banks listed in the Banking Company's Acquisition Acts of 1970 or 1980. Scheduled bank is one listed in the second schedule of the RBI Act, 1934. And a bank authorized for government agency business is one notified by the Finance Ministry's Department of Expenditure for that purpose. Different roles in handling scheme funds.
How does the corporation plan its finances? What's the budget process?
The Director General drafts the initial budget estimates. These go to the Standing Committee and then the full corporation for review and approval. Once approved internally, it's certified with the corporation's seal and sent to the central government by the end of March before the financial year starts.
Does the government get final say?
Yes, the central government can make modifications before final approval. The approved budget is then laid before Parliament by the relevant ministry and also published. Keeps it transparent.
Okay, let's talk gratuity payments. When is gratuity normally due?
Generally, it becomes due within 1 year from the date it actually became payable under the code. If it was due before these rules came into effect, the 1-year clock starts from when the rules became effective.
What if someone is late applying for their gratuity? Can they still get it?
Yes, they can still apply to the employer, but they need to provide a good reason for the delay. The competent authority can then direct the employer to pay it and potentially order them to pay interest for the delay period too. Acknowledges valid reasons for late claims.
And if an employer disagrees with a gratuity order and wants to appeal, what's the process?
They have to appeal to the appellate authority within 60 days of the original order. The authority might allow more time if there was a really good reason for the delay. Crucially, the employer must deposit the amount of gratuity they admit is payable before the appeal is even considered.
What does the appeal itself involve?
It's submitted as a memorandum of appeal, stating facts, the decision being appealed, grounds for appeal, and what relief they want. Needs a certified copy of the original order attached. The competent authority sends the case records up. The appellate authority has powers to summon witnesses, get documents, and can confirm, modify, or reverse the original order. Their decision is recorded and sent back down.
Back to the building cess. When do employers submit returns for this?
They submit a return in Form 8th to the assessing officer within 7 days of completing each construction project.
What about advance payments they might have made?
Any advance cess paid gets adjusted against the final assessment order for that project. Prevents overpayment.
How does the collected cess money get to the Building Workers Welfare Board?
It's transferred electronically to the board's bank account. This is done by specified government offices, PSUs, local authorities, or the assessing officer responsible. Ensures funds go where they're intended.
How does the assessing officer actually assess the cess liability?
When they get the return, Form A8, they examine the info. If satisfied, they issue an assessment order within 90 days, stating the total cess payable. Copies go to the employer, the cess collector, and the welfare board.
What if an employer paid too much cess? How do they get a refund?
They can apply to the assessing officer, explaining why they think they overpaid. The officer verifies the claim. If valid, they issue a refund order, sending copies to everyone involved. The welfare board is then responsible for processing the refund within 30 days, usually via online payment to the employer's bank. Similar process if an appeal reduces the assessed amount.
Can unpaid cess dues ever be just written off?
Yes, under specific conditions, but it needs approval from a designated board officer. Situations include: the establishment closed over 5 years ago and the employer can't be found. It's impossible to enforce a decision because the employer has no assets, or an undertaking to pay remains unfulfilled. Basically, when recovery is truly impossible.
How are the corporation's own accounts checked? Audited.
Annually by the Comptroller and Auditor General, SEC of India. The audit report goes to the central government, who then tables it in Parliament.
What happens if the audit finds problems?
The Standing Committee has to address any objections raised in the report and inform the central government within 90 days about the actions taken. If there's disagreement or inaction, the central government can issue directions. There's also a provision to surcharge individuals responsible for any financial loss or waste. Accountability.
What information do employers need to send annually to regional career centers?
By March 31st each year, they need to report details like total manpower by category and gender, people recruited, occupational details of current staff, vacancies they couldn't fill, and anticipated future vacancies. The government can require this from private sector establishments too.
Who oversees these career centers for employment information purposes?
The Director of Employment, or equivalent officer in the state, who controls the regional career centers, is responsible for overseeing their function under Chapter 13 of the Code, Employment Information and Monitoring.
Let's look at the Provident Fund and Pension Scheme Boards of Trustees. How are they composed?
Key principle is equal representation of employers and employees, numbers as per the scheme rules. If an establishment is exempted, its employer chairs the board, maintaining arm's length principles and having a casting vote in ties. They must meet at least once every 3 months. The central GOVT or central PF commissioner can also call meetings.
Form AX came up again. What's its specific use?
It's the application to the competent authority for the recovery of contributions. So it's used to formally request the authority to step in and recover unpaid contributions under Chapter 5 of the Social Security Code.
Let's dig deeper into maternity benefit rules. Are there times when an employer absolutely cannot employ a woman?
Yes, very specifically. No employer should knowingly employ a woman during the 6 weeks right after delivery, miscarriage, or medical termination, nor during any period when delivery is likely within the next 6 weeks. Also, they shouldn't assign her work that's arduous or likely to harm her health during these sensitive times.
We covered the 80-day work requirement for eligibility. Anything else?
Just to reiterate, subject to other code provisions, any woman who meets the 80-day work criteria, including legal strike lockout days, in the 12 months before expected delivery, and who claims the benefit, is entitled to it for her actual absence, up to the maximum allowed period, 26 weeks total, max 8 weeks before expected delivery.
And the employer's responsibility is?
To pay the maternity benefit for the entire period, according to the code and rules.
Is there a way to get some of the benefit paid before the baby arrives?
Yes, the amount due for the period before expected delivery can be paid in advance by the employer. This usually happens after the woman submits Form X, a certificate confirming pregnancy and expected delivery within 6 weeks. The rest is paid after she provides proof of childbirth within 48 hours of delivery.
Building cess again, can it be deducted directly from payments?
Yes, the rules allow for deduction at source, often used for government contracts, etc., ensures collection.
When employers report cess paid in Form 4, what if the project took years?
If construction takes more than a year, they need to detail the cess paid specifically for each year of the project. Provides a clear annual breakdown.
How is the contribution assessed for aggregators engaging gig and platform workers, at least initially?
Provisionally, it's based on a percentage of their annual turnover, as notified, or 5% of their liability to those workers in the previous year, whichever is lower. They also have to declare they know the penalties for incorrect self-assessment or concealing facts.
What's required in the main annual return employers submit under the Social Security Code?
Sent to the Career Center, it needs employer establishment details, type public-private, nature of business, registration number, crucially, detailed employment numbers, full-time, part-time, apprentices, casual, contract broken down by gender, and persons with disabilities, PWD, and occupational details using actual job titles.
There's another draft notification mentioned specifically on the building cess rate.
Yes, that one proposes fixing the rate at 1% of the total cost of construction. And again, it invites objections and suggestions from the public.
Who should people contact for feedback on that specific notification?
Objections, suggestions go to Shri Rahul Bhagat, a director at the Ministry of Labor and Employment, either by post or email, rahul.hagat@ips.gov.in. Standard pro forma expected for submissions.
Given all these rules, the definitions must be really important. You mentioned some earlier.
Absolutely critical for clarity. Terms like act, assessment, assessing officer, cess, code, contractor, corporation, employer, establishment, factory, fund, insured person, portal, principal employer, scheme, tribunal, worker, all have specific legal meanings within this context. Understanding them is key to understanding the rules.
How do establishments actually get registered under these regulations? What's the process?
It's primarily online via the Shram Suvidha portal. Employers enter details about their establishment name, address, business type, employee numbers, etc., and upload necessary documents.
And then what happens?
A unique labor identification number, LIN, is generated automatically. This registration is mandatory if you employ even one person. If any registered details change, the employer has 30 days to update them online. If the business closes, they apply for cancellation online, and they have to display a copy of the registration certificate at the workplace.
Let's recap the Central Board for the Employees Provident Fund, composition and functions.
It includes ex officio central GOFT members, representatives from employer and employee organizations appointed by GOFT, some employee reps elected by the board itself, and the Central Provident Fund Commissioner. Its main job is administering the PF funds according to government guidelines and any other duties assigned under the code. There's also an executive committee that assists operating under the board's control.
How long do the appointed trustees serve on this central board?
5 years from their notified appointment date, they continue until a successor is named. If filling a casual vacancy, they serve the remainder of that term. Maximum tenure is 2 terms total.
And the Employees State Insurance Corporation composition and functions again.
Very broad membership. Ex officio GOFIT members, state GOFIT reps, employer-employee reps, MPs, 2 Lok Sabha, 1 Rajya Sabha nominated by GOFT after consultation, and other nominated members. Their term varies. Main functions: administer the ESI fund and provide benefits under the code. They can also form other committees to help. Non-official members limited to 2 terms.
These other committees the ESI Corporation can form, what's their role?
They're basically support structures. The corporation can set them up with specified compositions, relevant expert stakeholders, to help manage specific areas of the ESI scheme efficiently, maybe finance, benefits, specific projects, assists the main corporation.
Terms of office for ESI Corporation members.
Varies by category. Some serve at the pleasure of the central GOFIT. Rep states, employers, employees, MPs have fixed terms. Non-official members capped at 2 terms.
And the standing committee members within the ESI Corp?
4-year term for non-ex officio members.
How are the MPs actually nominated?
The central government consults the Speaker of Lok Sabha for Lok Sabha nominations and the Chairman of Rajya Sabha for Rajya Sabha nominations. Formal process involving the heads of the houses.
How are the central government's own representatives chosen?
The central gov directly nominates 10 members representing relevant ministries departments involved with the Social Security Code, ensures government policy is represented.
The National Social Security Board's general functions, quick recap.
Recommends schemes, unorganized gig platform workers, monitor implementation of those schemes, and advise the central government on related matters.
Meeting procedures for all these main boards. Central Board, Corporation, National Board. Any common rules?
Yes, generally similar protocols. Meet as prescribed frequency, 21 days notice usually needed, shorter for urgent meetings if chair approves. Agenda set by chair, stick to agenda unless chair allows deviation. Chair or vice chair presides. Quorum needed. Adjournment rules. Members can nominate substitutes if they can't attend, in writing, with reason.
How are minutes handled? Recording and confirmation.
Secretary records minutes. Circulates draft copies to attending members. Confirmed at the next meeting, then signed by the chairperson of that meeting. Confirmed minutes sent to Central Govard within 15 days. Minute books open for member inspection.
Do non-official members get paid for attending these meetings?
Yes, they get traveling and daily allowances as per government rules for attending meetings of the main boards or their subcommittees. Official members get allowances per their own service rules.
Appeals to the tribunal. Let's go over that procedure again in detail.
Okay. File appeal within 60 days of the order you're contesting. Tribunal might grant another 60 days if there's sufficient cause for delay. Employer must deposit assessed dues before appeal is heard. Appeal submitted electronically or typed, double-spaced. Needs paper book with certified order copy supporting documents, index. Signed by appellant or authorized rep, lawyer, union employer, org, official.
Tribunal powers.
Summon witnesses, compel documents, adjourn, hold ex parte hearings and set them aside, issue orders directions. Procedure for substituting legal reps if someone dies during appeal. Parties can have legal representation. Tribunal has official seal. Staff have dress code.
Managing the ESI fund, where does the money come from and how is it invested?
Sources: contributions, grants, donations, interest, rent, penalties, permissible investments, Gorvit securities, scheduled bank FDs, approved financial institutions, other approved securities. Changing investments needs care, requires central GOFT approval if likely to cause loss.
Can the corporation borrow money?
Yes, but needs central GOFT approval and only for specific purposes. Land building acquisition, loan repayment, other approved reasons. Borrowing terms mutually agreed. Can't charge loan expenses to capital without GOFT sanction. Annual statement on loans submitted to GOFT.
How are employees actually insured under ESI? Whose responsibility?
Employer's responsibility to insure them before they start work, unless already registered. Employer issues contribution card, furnishes necessary employee particulars.
Does the government help employers with their share of ESI contributions for lower paid workers?
Yes, the central GOFT reimburses the corporation for the employer's share for employees below a specified wage threshold for up to 3 years. Helps offset costs for employers.
ESI Corporation's administrative expenses, what's included again?
Salaries, allowances, PF contributions for staff. Costs of providing medical benefits, office expenses, rent, maintenance, vehicles, legal costs, publicity, evaluation studies.
Disablement benefit calculation, let's nail that down.
Daily rate is 90% of the standard benefit rate, rounded up. The full rate is based on average daily wage on the accident date, rounded up. Temporary disablement gets the full rate for the duration. Permanent total disablement gets the full rate for life. Permanent partial disablement gets a percentage of the full rate based on the loss of earning capacity listed in the fourth schedule for that specific injury.
Medical benefit entitlement, can it be extended?
Yes, if someone qualifies for extended sickness benefit, their medical benefit is also extended for that same period. The rules also cover the general scope for insured persons and families, ESI medical institutions, and potential user charges, subject to corp approval.
ESI Corp proceedings, how do they start? Where are they held?
Started by filing an application by the corporation, an aggrieved person, or an employer. Jurisdiction is usually where the insured person was working when the issue arose. The court can transfer cases to another ESI court in the same state for convenience following state rules. Parties are informed of transfers.
Quick recap. Specific forms for gratuity and maternity benefit.
Gratuity. Form 3, nomination. Form V, notice for payment. Form 8, notice after appeal. Maternity. Form 11, woman's notice claiming benefit. Form 12, expected confinement certificate. Form 3, appeal against denial.
Procedures under older acts like payment of wages, minimum wages, equal remuneration. How do they relate?
The rules state that the existing procedures under those acts regarding authorities, appellate authorities, appeals, and the Central Advisory Board apply for relevant matters under these broader rules too. Leverages existing frameworks.
Weekly day of rest rules.
Mandatory weekly rest day. Can be substituted with another day if proper notice is given. Defines continuous period for entitlement. Layoff days don't break continuity.
Wages for the rest day. Or working on it.
Wage for rest day is at the rate of the preceding day. If worked on rest day with substitution, paid overtime rate for the day worked, and regular rate preceding days for the substituted rest day. Specific calculation for monthly rated wages based on 26-day month.
What deductions can legally come out of wages?
Only those listed in Section 18. Fines, absence, damage, loss, entrusted goods, housing, amenities, advances, income tax, court orders, PF, other notified deductions. Total deductions are limited. Employer must inform employee within 15 days about deductions for damage loss.
How are wage advances recovered?
Recovered from wages in installments, amount and number determined by the designated authority. Regulated repayment.
Bonus calculation, the schedules.
Yes, Schedules A, B, C detail how to calculate a lockable surplus and bonus. B is for banking companies, C for others. A explains carrying forward surplus shortfall over 4 years.
Prior charges deducted before bonus calculation. Schedule C.
Depreciation, development rebate allowance if not written back, direct taxes, and a specified return on capital reserves. Essential costs deducted first.
Minimum Wages Act schedules relevant examples.
Schedule 1 includes stone breaking crushing, relevant to mining. Schedule 2, Part 1 lists many manual hour skilled jobs, road construction, building, transport, textiles, etc. Part 2 lists agriculture, specific skilled, semi-skilled roles usually detailed in industry-specific wage notifications.
Inquiry officer procedure after admitting a complaint.
Notify the person complained against, electronically somewhat on portal posting, with date, time, venue. Tell them to bring documents, witnesses. Inform complainant of the date too.
What if the person complained against doesn't show up?
Inquiry officer can proceed ex parte, hearing only the complainant's side and available evidence before deciding.
Contract labor license security deposit the rule.
Contractor deposits bank guarantee of $1,000 VAROS per worker before license issue, ensures compliance with license conditions and code rules. Financial assurance.
Can that deposit be used for a renewed license?
Licensing officer has discretion to adjust the old deposit towards the new one if the applicant requests it. Streamlines renewal for compliant contractors. So, as you can probably tell, we've covered a massive amount of detail. You really should have a very comprehensive grasp now of these draft rules and the associated regulations. We've gone from public feedback right through to, the nitty-gritty of working conditions, social security bodies, legal processes.
Absolutely. It was a true deep dive, wasn't it? Mm-hmm. And hopefully everyone listening feels much more clued in on this, complex but really vital area of labor law. For me, I think one of the aha moments was just how specific everything is. Mm-hmm. Like the exact format for feedback or the precise data needed on those mind forms. It just highlights the sheer level of detail involved in crafting these legal frameworks.
And that's often the key, isn't it? Being well-informed isn't just about the big picture. Understanding these specifics is often where you see the real practical impact and the intended protections for everyone involved, employers and employees alike.
Yeah, this has definitely laid a solid foundation. But as always, there's always more to explore. We'd really encourage listeners to think about how these regulations impact the sectors they're interested in. Maybe even look the source documents themselves for specific points.
Exactly. And I suppose the final thought is just recognizing how interconnected all these rules are. They work together, aiming to build a framework for fair, safe, and equitable working conditions. It's a constantly evolving area, and understanding these details, it's crucial for everyone involved. Welcome back to the Deep Dive.
Great to be here.
Today, we've got quite the task ahead of us. You've sent over a whole stack of documents, notes, analyses, official gazettes, all covering the new Indian labor laws.
Yeah, it's a significant amount of material. We've got excerpts from All Notes 422, Duro 225, the Indian labor law reforms, analysis, and then the actual gazettes for the Social Security Code, the IR Code, the OSH Code, and the Code on Wages.
Exactly. And our mission really is to synthesize all of this. We want to create one single comprehensive audio resource.
Kind of like a spoken word replacement for digging through all those PDFs yourself.
Precisely. The goal is to capture every key detail, all the essential information, so listeners have a solid understanding without needing the original documents. And crucially, in clear, easy to understand English.
Right. We'll cover the definitions, the rules, the regulations across all four main codes: Social Security, Industrial Relations, OSH, and Wages. We'll aim to be thorough.
Okay, let's start building that picture then. Basics first. Where do these labor codes apply geographically, and when do they actually start?
Okay, good place to start. Fundamentally, all these labor codes, they apply to the whole of India.
Okay, nationwide.
Nationwide. But the when is a bit more complex. They don't all just switch on at once.
Right.
Each code, and actually even specific parts within each code, will come into force on a date the central government appoints. They'll announce it through an official notification in the Gazette.
So you can see different bits activating at different times.
Exactly. You might have one chapter start in June, another in October, perhaps. So whenever we mention commencement for a provision, it just means the specific date that that part becomes law.
Got it. So it's a staggered rollout, potentially. Now, navigating these documents, there are so many specific terms. Definitions are going to be key.
Absolutely crucial.
Can we kick off with some core concepts? For instance, what exactly counts as an industrial establishment or undertaking? That sounds pretty fundamental.
It is. And the definition is, well, quite broad. It essentially means any place where any industry is carried on.
Okay, pretty wide net.
It is. And there's an interesting point. If you have a bigger establishment with several distinct units, and maybe one or more of those units could be considered an industry on its own,
Yeah.
then each of those self-contained units can actually be treated as a separate industrial establishment under the law.
Ah, so it allows for some modularity in how you look at big companies.
Kind of, yes. It provides some flexibility there.
Okay. And what about the term worker, who falls under that definition in these codes? Seems like another really important one.
Hugely important. Generally, a worker includes anyone doing skilled, semi-skilled, or unskilled manual work.
Right.
But also operational, supervisory, technical, or clerical work, all for hire or reward, of course. So it covers a wide range of jobs.
But there are exclusions, right? Who isn't considered a worker?
Yes, there are key exclusions.
Okay.
Firstly, anyone under the Air Force Act, the Army Act, or the Navy Act, so Armed Forces personnel.
Makes sense.
Also, people employed in the police service, or as officers or employees of prisons, they're out.
Okay.
Then individuals who are mainly in a managerial or administrative role.
Right. The management layer.
Exactly.
Yeah.
And there's a specific point about supervisors. If someone is in a supervisory role and earns more than 18,000 rupees per month, or whatever amount the government notifies later, they're generally not considered a worker.
Ah, a wage threshold. Interesting.
There is one exception to that supervisory exclusion, though. It doesn't apply for the purposes of Chapter 3 of the Industrial Relations Code, which deals with trade unions.
Okay, good nuance to note. So that wage limit adds a bit of complexity, especially with that carve-out. What about the term accounting year? When does that run from?
Simple one, thankfully. For these labor laws, the accounting year always starts on the first day of April.
April 1st, standard.
Yep. Provides a consistent time frame for reporting and compliance across the board.
And we see the term appropriate government used a lot. Sounds like it depends on the situation.
It absolutely does. The appropriate government is basically the authority responsible for enforcing the law for a specific establishment.
Okay.
So if it's an undertaking under the central government's authority, central public sector units, railways, that kind of thing, then the central government is the appropriate government.
Right.
For pretty much everything else operating within a state, the state government of that particular state is the one responsible.
Okay, that clears that up. Now, one of the analysis documents, the Indian labor law reforms one, used the term employee with a slightly different definition. How does that compare to worker? Any key differences?
Yeah, that's a good point to bring up. The employee definition in that specific analysis paper is similar in many ways to worker, but it had its own exclusions and, importantly, a different wage ceiling for supervisors at the time it was written.
Ah, okay.
Like the worker definition, it excluded police, prison staff, and those mainly in managerial or administrative roles.
Right.
But the supervisory wage cutoff in that analysis was set at 15,000 rupees per month.
Lower than the 18,000 for worker.
Exactly. But the analysis did clearly state that this 15,000 limit was subject to future change by government notification. So initially, it was a lower threshold in that specific document's definition.
Got it. So potential for those numbers to align or change over time. Let's switch gears to the Social Security Code. This seems like a really major piece. What's the actual definition of Social Security within this code?
Right. The Social Security Code defines Social Security as the protection society provides.
Yeah.
It's about ensuring access to health care and guaranteeing income security.
Income security against what specifically?
Well, against various life events, things like old age, unemployment, sickness, becoming disabled, work injuries, maternity, or sadly, the loss of the main breadwinner in a family.
Okay.
And this protection comes through rights given by the code itself and also through specific schemes set up under the code.
The code also talks about the unorganized sector and unorganized workers. Can you break those down for us?
Sure. The unorganized sector refers to enterprises owned by individuals or self-employed people. They're involved in producing goods, selling goods, or providing services.
Okay.
The key thing is the size. If they employ workers, the total number has to be less than 10.
Less than 10 workers. Got it.
And an unorganized worker is someone who works in that sector. They could be home-based, self-employed, or a wage worker.
Right.
Interestingly, the definition also includes workers in the organized sector who aren't covered by the old Industrial Disputes Act or by certain chapters 3 to 7 of the Social Security Code itself.
So it's trying to catch those who fall through the cracks, even in the formal sector.
Exactly. It shows the intent to really broaden that Social Security net.
And then we have terms that are very relevant today: gig worker and platform worker. How does the code define them?
Yeah, these are crucial definitions for the modern economy. A gig worker is someone who performs work or participates in a work arrangement and earns from it outside a traditional employer-employee relationship.
Like freelancers.
Precisely. Freelancers, independent contractors, people working on specific projects, temps, part-timers, arranged through various platforms.
Okay.
And the code also specifically defines aggregators. These are essentially the digital middlemen, the online platforms that connect the service providers, the gig workers, with the customers.
Gotcha. Okay, let's shift to responsibilities within the workplace. The term occupier comes up, especially for factories. Who is the occupier according to these laws?
The definition of occupier for a factory mostly follows the Factories Act of 1948. It's the person who had ultimate control over the factory's affairs.
Ultimate control.
Yes. And importantly, if a manager has been officially named under that act, that manager is also considered the occupier.
Okay. What about places that aren't factories?
For other establishments, the occupier is the person or the authority with that ultimate control over operations.
Similar principle.
Very similar.
Yeah.
And if the day-to-day running of the place is entrusted to a manager or a managing director, then that person is deemed the occupier. There's also a special mention for ships being repaired in dry docks. Usually the owner of the dry dock is the occupier, but for things related to the ship's condition itself, the ship owner remains responsible.
Okay, specific but clear. Now, the Industrial Relations Gazette, the Gazette, has a ton of definitions. One really critical one is wage. It seems fundamental to so many rules.
Yeah.
What's included and excluded under the IR code?
Absolutely. Wage is foundational. Under the IR code, wage includes your basic pay, any dearness allowance, DA, and also any retaining allowance.
Okay, basic pay, DA, retaining allowance, what's not included?
Right, the exclusions list is quite long. It does include any statutory bonus, the value of house accommodation provided by the employer, or things like light, water, medical attendance supplied by the employer. Also excluded are employer contributions to pension or provident funds, conveyance allowances, special expenses related to the job, house rent allowance, HRA, overtime pay, and commissions.
Wow, okay. Lots of common components excluded.
Yes, and also gratuity paid on termination, retrenchment compensation, other retirement benefits, or any ex gratia payments made when employment ends. Those are all out of the basic definition of wage.
But there's a catch, isn't there? Something about 50%?
There is. It's a very important condition. If the total of the included parts, that's basic pay, DA, and retaining allowance, adds up to more than 50% of the total remuneration,
Okay.
then the amount that exceeds that 50% threshold is actually considered remuneration. It gets added back into the calculation of wages for certain specific purposes.
So if allowances and exclusions make up too much of the total pay package, some of it gets reclassified as wage.
That's the essence of it. It prevents structures where the basic wage is artificially low. It's a really crucial detail for calculating benefits and obligations tied to wages.
Definitely seems like one to watch closely when looking at pay structures. That Gazette really is a deep dive on definitions itself. It covers so much more.
It really does.
It defines adolescent, adult, agent for mines, gives that detailed breakdown of appropriate government for banks, controlled industries, defines core activity, and lists exclusions like sanitation, security, canteens.
Yeah, unless providing those services is the main business, of course.
Right. And definitions for dock worker, a broad employee definition specific to that code, what counts as family.
And the family definition is quite detailed there. Dependent spouse, kids under 18, dependent parents, grandparents, even dependent widowed daughters or sisters.
Wow, okay. And it keeps going. Go down. Hazardous substance, industrial premises, medical officer, metro railway, a really detailed definition of mine.
Very comprehensive on mines. Also, motor transport worker with its own inclusions and exclusions, newspaper establishment, including common control scenarios.
Office of the mine, plantation based on land size and crop type, port authority, power, prescribed.
Which just means prescribed by the relevant government rules.
Standard, registered trade union, river navigation company, seaman, shop, social security organization, state government, state public sector undertaking.
Trade union itself, transport vehicle, and as we discussed, another very detailed breakdown of wages with its own nuances and sometimes a supervisory wage limit. And finally, working journalist.
It's incredibly granular. That level of definition is clearly vital for applying these laws correctly.
Absolutely. Precision is key.
Now, the Social Security Code Gazette also has its own long list of definitions. There's some overlap, obviously, but often with a specific Social Security slant.
Exactly. They're tailored to the purpose of that code.
Like building or other construction work, it lists what's included, but also exclusions based on worker numbers, or if it's a small personal house bill below a certain cost threshold.
Right. And it defines terms relevant to Social Security benefits, like commissioning mother, company, referencing the Companies Act, compensation in the SS Code context, competent authority for different chapters.
Confinement, consignment, contract of service, contract labor, contractor, contribution specifically for SS schemes, the corporation, meaning the ESIC.
Date of superannuation,
Yep.
a very detailed list of who qualifies as a dependent, director general, and importantly, disablement.
How is disablement defined?
It covers both temporary and permanent disablement, and it even classifies the severity. Very important for compensation claims.
Okay, and it continues. Employee, very broad here, employer, including legal reps, employment injury, establishment, defined differently perhaps for different chapters.
Yes, the applicability can vary. Then factory, financial year, fixed term employment, the fund, meaning the EPF, gig worker again, goods and services, gratuity,
Home-based worker, identity card, the insurance fund, insurance scheme, insured person, license, local authority, lockout, managing director, medical benefit, medical board, the National Social Security Board.
a key body we'll discuss later. Notification, platform work, platform worker, provident fund scheme, registered medical practitioner, relevant period, schedule, scheme, self-employed worker, the Social Security Code itself.
The Social Security Organization, state government, the State Unorganized Workers Board, superannuation, with a specific age for one chapter, temporary disablement, tribunal, unorganized sector, unorganized worker, and wage again.
With its own detailed inclusions, exclusions, and extra conditions about equal wages and payment purposes.
And finally, wage ceiling, wage worker, and worker, one more time. It's exhaustive.
It needs to be, given the scope.
And lastly, the Code on Wages also has its definitions, often similar but focused on wage issues.
Correct. Employer includes legal reps and contractors. Establishment is any place of industry, trade, business, etc., including government ones.
Factory points back to the Factories Act.
Yes, government establishment is defined. Industrial dispute points to the Industrial Disputes Act definition.
And worker under the Wages Code.
Again, very broad manual, unskilled. skilled, technical, operational, clerical, supervisory. Includes working journalists and sales promotion employees.
But excludes armed forces, police, prison officers.
And those mainly in managerial or admin roles.
Yeah.
Consistent exclusions there.
Okay. It's clear that a huge part of understanding these codes is just getting the terminology straight. That was a necessary, if lengthy, foundation.
It really was. Without clear definitions, the rules themselves become ambiguous.
Right. So let's move on to how disagreements get resolved. The Industrial Relations Code sets up industrial tribunals and a national industrial tribunal. How are these bodies formed and what's their main job?
Okay, dispute resolution. The appropriate government, remember, central or state, depending on the establishment, they can set up industrial tribunals to handle disputes in their area.
Right.
The central government, specifically, can also set up national industrial tribunals. These are for disputes considered of national importance, or maybe those involving businesses operating in multiple states.
And who sits on these tribunals?
They generally have a two-member structure. There's a judicial member for the National Tribunal. This has to be someone who is or has been a high court judge.
Okay, serious legal background.
Absolutely. And then there's an administrative member. This person needs to have practical experience in labor matters. For the National Tribunal, this might be someone like a former secretary to the government of India.
So a mix of legal and practical expertise.
That's the idea, trying to get a balanced perspective on the disputes.
And who presides over the national tribunals?
The judicial member is the presiding officer for the National Industrial Tribunal. Their legal expertise guides the process.
What about the actual procedures these tribunals follow? Are there set rules?
The exact, detailed procedures will be laid out in rules that are yet to be formally prescribed.
Okay.
But the code does say that certain kinds of cases must be heard by a bench with both the judicial and administrative members present.
To ensure that dual perspective is applied.
Precisely. For specific important cases, they want both viewpoints involved in the decision.
What if the two members, judicial and administrative, just can't agree? If they have different opinions on a case?
That's covered. If they disagree, the issue gets referred back to the appropriate government.
Okay.
The government then appoints another judicial member. The case is then decided by a majority vote among the original two, plus the new judicial member.
A sort of tiebreaker mechanism. And finally, who can be a member? Are there independence criteria or age limits?
Yes, independence is key. Members must be independent individuals. And there's an age limit. They can't continue serving on a tribunal after they turn 65.
65, okay. Keeps the membership fresh over time, I suppose.
Potentially, yes.
Let's move to industrial actions now. The IR code talks about illegal strikes and lockouts. When does a strike or lockout become illegal under this code?
Right. A strike or lockout is considered illegal if it's started or declared in violation of Section 62 of the code.
Which presumably sets out the proper procedures, notice periods, etc.
Exactly. It outlines the legal requirements before you can initiate such an action. Also, it becomes illegal if it's continued against an order issued under Section 42(7).
And what might that order be about?
That likely relates to orders prohibiting the continuation of a strike or lockout, perhaps while conciliation or arbitration is underway.
Okay. Are there exceptions? What if a strike or lockout was already happening when the dispute gets sent to a tribunal or arbitration? Is it automatically illegal then?
No, not automatically. There's a specific clause for that. If the strike or lockout was already going on when the case goes to the tribunal or arbitration, it doesn't automatically become illegal.
What's the deciding factor then?
Two things. Was its start lawful according to the code? And has its continuation been specifically prohibited by an order? If the start was legal and there's no order stopping it, it can continue legally even while the dispute resolution process is happening.
I see. So the timing of the referral doesn't automatically nullify a legally initiated action. The IR code also has special rules, Chapter X, I think, for layoffs, retrenchment, and closure in certain types of industrial establishments. What are the key things there, especially regarding conditions for retrenchment?
Yes, Chapter X applies special provisions, but mainly to larger industrial establishments, likely defined by the number of workers. For retrenchment in these covered establishments, the code sets out conditions precedent.
Meaning things the employer must do first.
Exactly. Before retrenching a worker covered by this chapter, the employer generally have to give the worker a specific notice period in writing, or pay wages instead of giving notice.
Notice or pay in lieu. standard.
Yes. And crucially, they also have to pay retrenchment compensation, calculated according to the rules in that chapter, usually based on length of service.
Okay. And what about the permanent closure of one of these larger establishments? What's the government's role?
For those establishments covered by Chapter X, again, likely the larger ones the employer needs prior permission from the appropriate government before they can close down.
They have to ask first.
They have to apply formally for permission. The government then reviews the application and can either grant or refuse permission.
And is the government's decision final?
Generally, yes. An order granting or refusing closure permission is usually final and binding on everyone for 1 year from the date of the order.
Usually. Are there exceptions?
Yes, it's not absolute. The government can review its own order later if needed, or it can refer the matter to a tribunal for adjudication. So there's a bit of flexibility there.
Okay. Now, the labor law reforms analysis mentions central and state advisory boards being set up. What's their role supposed to be?
Right. The analysis document mentions these boards as part of the reform structure, while it doesn't go into exhaustive detail on their duties.
Yeah.
The typical function of such advisory boards is to provide expert advice and recommendations to the government, central or state, on labor law matters and how to implement them effectively.
So a source of expert input.
Exactly. They often act as forums for discussion between stakeholders, employers, employees, government, to help shape policy in a more informed way.
Makes sense. Let's dive deeper into the Social Security Code now. The rationale mentioned fixing issues like the huge informal sector and low female participation in the workforce. Why were these such big drivers for reform?
They are absolutely central drivers. Firstly, the informal sector in India is massive, around 90% of the workforce.
90%? Wow.
It's huge. And workers in this sector often lack formal contracts, predictable income, and crucially, access to traditional Social Security like health insurance, pensions, unemployment support. Extending coverage here is a primary goal.
Okay, that's a clear need. What about female participation?
That's the second critical issue. Female labor force participation rates in India are worryingly low, and according to the data reference from 2017-18, had even been declining in rural areas.
Declining.
Yes, down from about 28% to 25% between 2011-12 and 2017-18 in rural areas, while urban rates stayed low, around 20%. These numbers highlight an urgent need for reforms that make it easier and safer for women to join and stay in the workforce.
Like better maternity benefits, childcare.
Exactly. Maternity benefits, childcare support, safer working conditions. These are all key parts of a Social Security system that can support higher female participation.
The code also mentions alignment with ILO Convention number 102. Why is that significant?
Referencing ILO Convention 102, the Social Security Minimum Standards Convention is important. It shows that India's existing systems already touch upon many of the 9 core branches of Social Security defined internationally by the ILO.
Which branches are those?
Things like medical care, sickness benefit, unemployment, old age benefits, employment injury, family benefits, maternity, invalidity, and survivor's benefits.
So it's building on an existing foundation aligned with global standards.
Precisely. The reform aims to strengthen and expand this foundation, bringing it more in line with international best practices while extending coverage.
Chapter 6 of the SS Code covers maternity benefit. What are some key provisions there supporting women?
Chapter 6 has several important points. If a woman unfortunately passes away, any maternity benefit due to her goes to her nominee. If the employer doesn't provide free pre- and postnatal care, the woman gets a medical bonus. The figure mentioned is 3,500 rupees.
A fixed bonus amount.
Yes. Also, there's provision for paid leave 6 weeks following a miscarriage or medical termination of pregnancy.
That's important.
And very practically, until a child is 15 months old, the mother gets 2 nursing breaks during the workday, in addition to her normal rest breaks. Essential support for breastfeeding mothers returning to work.
Definitely. Now, Chapter 7 is about employees' compensation for work injuries or death. What stands out there?
Chapter 7 strengthens the compensation process. The competent authority can require employers to submit detailed statements about fatal accidents within 30 days of being notified.
Okay, faster reporting.
Yes. And the state governments appoint these competent authorities who need specific qualifications like being from the judicial service or an experienced advocate or a senior gazetted officer.
Ensures qualified oversight.
Right. And if a fatal accident happens and the authority thinks the initial compensation deposited by the employer isn't enough, they can actually demand the employer deposit an additional amount.
So they can ensure the compensation is adequate.
That's the goal, making sure the amount truly reflects the loss.
Chapter 9 is specifically for Social Security for unorganized workers. What are the main takeaways for this huge group?
Chapter 9 puts the onus on state governments to create and notify welfare schemes for unorganized workers.
What kind of schemes?
It can be quite broad. Provident funds, help for employment injuries, housing assistance, educational support for kids, skill training, funeral assistance, even old age homes.
A wide range of potential support. How are these funded?
Funding can come from various sources. Wholly by the state, and partly by contributions from workers or employers, or even from other sources like CSR funds.
Flexible funding. Who is eligible to register?
Generally, an unorganized worker who is 16 years or older, or another prescribed age, and provides the self-declaration with their details.
And does this cover gig and platform workers too?
Yes, crucially, Chapter 9 explicitly includes gig and platform workers within the scope of these welfare schemes, acknowledging the changing nature of work.
That's a significant inclusion. The highlight section of the SS Code mentioned wider coverage overall. Can you recap the main advancements?
Sure. The big picture is wider coverage. It goes beyond the organized sector to include unorganized, home-based, self-employed, fixed-term workers, gig, platform, interstate migrants, and contract employees.
A much broader net.
Definitely. It also mandates appointment letters for all workers, a step towards formalization. The OSH code rules apply even to small hazardous workplaces, under 10 workers.
Okay.
The definition of interstate migrant worker is broader now, including those directly employed. And ESIC coverage is expanding voluntarily to all districts and establishments with 10+ employees, moving beyond the old notified area system.
So a more inclusive framework overall.
That's the clear aim.
Let's turn to trade unions, covered in the Gazette. What happens to unions already registered under the old 1926 Act when this new code starts?
Good question. The IR code allows for a smooth transition. Existing trade unions registered under the 1926 Act are deemed registered under the new code.
Automatically.
Almost. There's a step they need to take. They have to file a statement with the registrar confirming their executive body's constitution aligns with the new code and provide their updated rules. Once that's done and checked, they're formally recognized under the new system.
Okay, a procedural step, but not re-registration from scratch. Do unions have ongoing duties under the new code?
Yes, they do. They need to inform the registrar if their membership drops below certain thresholds, either 10% of the total workers or 100 workers, whichever is less.
Right.
And they also have to keep the registrar updated about any changes to their registration details, their constitution, or their rules, keeping the records current.
What's the legal status of a registered trade union now?
Under the new code, it's formally a body corporate. It has its own legal identity, separate from its members. It has perpetual succession. It continues even if members change. It can have a common seal, own property, movable and immovable, enter contracts, and importantly, it can sue and be sued in its registered name. Formal legal standing.
Okay. The Gazette also mentions agreements reached via a negotiating council. How valid are those?
Very valid. If negotiations happen between an employer and a properly formed negotiating council under the code, any agreement they reach is legally binding.
Provided
it's agreed upon by a majority of the union representatives within that council. It reinforces the power of collective bargaining through these recognized structures.
How long does the recognition of a negotiating union or council last?
Typically, the recognition is valid for 3 years from the date it's granted or constituted.
3 years?
But it can be extended if the employer and the union council mutually agree. However, the total validity period, including extensions, can't go beyond 5 years.
Okay, a defined time frame with some flexibility. What about union finances? How are their funds regulated?
The code specifies what the union's general fund can be used for. It also covers the creation of a separate fund, often used for political purposes or other specific objects defined in the union rules.
Can members be forced to contribute to that separate fund?
No, absolutely not. Contribution is voluntary. And members who don't contribute can't be put at any disadvantage regarding other union benefits or rights, except, obviously, in managing that specific separate fund itself.
Right. Contribution can't be a condition for membership either.
Correct. That's explicitly prohibited.
There's an interesting bit about retired or retrenched employees holding union office. They're not considered outsiders.
That's right. The code clarifies that someone who has retired or been retrenched isn't barred from holding office in the union of the place they used to work just because they aren't currently employed there.
Why allow that?
It recognizes their potential continued connection, their experience, and the insights they might bring to the union.
I see. Finally, on unions, what's the process if a union wants to change its name or merge with another union?
For a name change, they need consent from at least 2/3 of their total members, following prescribed procedures.
Okay, high threshold.
Yes. For amalgamation or merging with another unions, the specific process will be detailed in the rules. In both cases, name change or merger, they have to send written notice to the registrar.
Who signs the notice?
For a name change, the secretary and at least 7 members. For an amalgamation, the secretary and at least 7 members from each merging union. And if the merged union's head office will be in a different state, the registrar in that state needs notice too.
Okay, clear procedures there. Let's move to standing orders, also in the Ur-Gazette. What are these, essentially, and how are they set up?
Standing orders are basically the rule book for employment conditions in an establishment. They cover things like working hours, leave, attendance, conduct rules, disciplinary actions, and so on.
The day-to-day rules of work.
Exactly. The central government creates model standing orders as a template. These apply provisionally until an employer gets their own specific ones certified.
How does an employer get their own certified?
They have to prepare a draft of their proposed standing orders first.
And then what happens with that draft?
They submit it to a designated certifying officer. The officer then has to notify the recognized trade union or negotiating union in the establishment.
What if there isn't one?
Then the notice goes to worker representatives chosen according to the rules. This ensures the workforce knows what's being proposed and has a chance to object or comment.
Makes sense. What information has to go with the draft standing orders?
The employer needs to include details about the workers, any unions they belong to, and identify the recognized union or negotiating body, if one exists. This gives the certifying officer context.
Can groups of similar employers submit a joint draft, say in the same industry?
Yes, that's possible.
Yeah.
If employers run similar establishments with similar work conditions, they might be allowed to submit a joint draft. It can streamline things.
What powers do these certifying officers and any appellate authorities have?
They have the powers of a civil court for their inquiries. They can receive evidence, administer oaths, compel witness attendance, demand documents. They're essentially acting in a quasi-judicial capacity.
What if there are minor typos or calculation errors in the certified orders? Can they be fixed?
Yes, there's a provision for correcting clerical or arithmetical mistakes, or errors from accidental slips. The officer who issued the order, or their successor, can correct these at any time.
Keeps things accurate. Once certified, how are these orders made available?
The certifying officer files a copy in a register, which can be electronic. And importantly, they have to provide a copy to anyone who asks for one, usually for a small fee. Ensures accessibility.
After certification, how long do they stay fixed before they can be changed?
Generally, they can't be modified for 6 months after they or the last modification came into effect.
6 months of stability.
Right. The only exception is if the employer and workers or their union representatives mutually agree to make changes earlier.
Okay. Let's shift to resolving industrial disputes, again from the Ur-Gazette. What's the main process?
The primary mechanism involves conciliation officers appointed by the appropriate government. Their job is to investigate disputes and try to broker a fair settlement between the parties.
So mediation is the first step.
Essentially, yes. The conciliation officer investigates thoroughly, looks at all the issues, and uses their skills to persuade the parties to reach an agreement. They can hold meetings, facilitate talks, suggest compromises.
What happens if they succeed, if a settlement is reached?
If they manage to get an agreement, the officer sends a report to the government, or an authorized officer, along with a memorandum of settlement.
A formal document.
Yes, outlining the agreement terms, and it must be signed by all parties involved in the dispute. That makes it legally binding.
What about ending a settlement or an award later? Can a party just walk away?
They need to give formal notice to the other parties if they want to terminate it. But crucially, that notice is only effective if it's given by a party that represents the majority of people bound by that settlement or award.
So one small group can't just unilaterally end it.
Correct. It requires majority backing among those affected.
The Gazette also covers recovering money owed to workers. What can a worker do if their employer owes them money under a settlement or award or specific chapters of the code?
If money is due under a settlement, award, or chapters IXX of the IR code, the worker, or their authorized representative or heirs if deceased, can apply to the appropriate government for help in recovering it.
They apply to the government.
Yes, if the government is satisfied the money is owed, they issue a recovery certificate to the local collector.
And the collector.
The collector then recovers the amount from the employer using the same powers they have for collecting unpaid land revenue, which is usually a pretty effective enforcement mechanism.
Right, that has teeth. Now, specific rules for strikes and lockouts. Are there notice requirements, especially for essential services?
Yes, there are definite notice requirements before a strike in a public utility service or before any lockout can happen. The exact details, how much notice, who gets it, will be specified in the rules made under the code.
What must employers do if they receive a strike notice or issue a lockout notice?
They have a duty to report it. Within 5 days of receiving a strike notice or giving a lockout notice, they must inform the appropriate government or a designated authority and the relevant conciliation officer.
Why?
It alerts the authorities to potential disruption, allowing them to potentially initiate conciliation efforts quickly. They also need to report how many such notices were received or given that day.
Okay. The IR Gazette also has that chapter on layoff, retrenchment, and closure, but it excludes seasonal or intermittent work establishments. Who decides if an establishment falls into that category?
If there's a dispute about whether an establishment is seasonal or intermittent, the decision of the appropriate government on that question is final.
Government has the final say.
Yes, avoids ambiguity there.
And within that chapter, how is industrial establishment defined? Is it the same broad definition as before?
No. For the specific purposes of this chapter on layoff, retrenchment, closure, industrial establishment has a narrower definition. It basically means a factory, as per the Factories Act, or a mine.
Factory or mine? More focused.
Right. It clarifies which types of places these specific rules apply to.
What if a laid-off worker is offered alternative work by the same employer? Can they refuse it and still get layoff compensation?
They might lose their compensation if they refuse suitable alternative employment. The conditions are quite specific, though.
What are the conditions?
The alternative job must be in the same establishment, or another one nearby, same town, village, or within 8 kilometers, belonging to the same employer. The employer must believe the worker has the skills needed, and the wages offered must be the same as their original job.
So if all those conditions are met and the worker still refuses?
Then they wouldn't be considered laid off for compensation purposes.
Okay. What compensation are laid-off workers entitled to, assuming they qualify?
A worker who isn't a bad lease or casual worker with at least 1 year's continuous service gets 50% of their total basic wages and dearness allowance for the layoff period.
50% of basic plus DA.
Yes, paid for all the days they are laid off, excluding weekly holidays that fall within that period.
Do employers have duties towards laid-off workers, like keeping track?
Yes, employers must maintain a specific muster roll for laid-off workers and make provisions for them to mark their presence if they show up for work at the appointed time.
So keeping records is important. Are there situations where a laid-off worker gets no compensation?
Yes. If the layoff is directly caused by a strike or go slow by workers in another part of the establishment, no compensation is payable.
Okay.
And as we just discussed, if they refuse that suitable alternative employment offer, they also forfeit the compensation.
Got it. Moving to retrenchment now. What conditions must an employer meet before retrenching someone with over a year's service?
For retrenching a worker with 1 year or more of continuous service, the employer generally has to meet those conditions precedent we mentioned.
The notice or pay in lieu?
Yes, give the required notice period in writing or pay wages for that period instead. And crucially, pay retrenchment compensation calculated based on their length of service according to the code's formula.
Are there special rules for mining or construction projects?
Yes. If an undertaking was set up specifically for mining or construction, buildings, bridges, roads, dams, etc., and it closes down because the work is finished,
Yeah.
and this happens within 2 years of it starting, the workers generally aren't entitled to the standard retrenchment compensation.
Because it was always temporary work.
That seems to be the logic. But if the work takes longer than 2 years, then the workers do become entitled to notice and compensation for every completed year of service, or part over 6 months.
Okay, a time limit distinction there. What about closing down a large establishment permanently? We mentioned prior permission is needed if it employs 100 plus workers.
Correct. For establishments with 100 or more workers, on any day in the preceding 12 months, the employer must apply to the appropriate government for permission before closing. The application needs to detail the reasons.
How long does the government have to decide? What if they don't respond?
The government should communicate its decision grant or refuse permission within 60 days of receiving the application.
60 days.
If the employer doesn't hear back within those 60 days, the permission is automatically deemed to have been granted. The application is considered approved by default.
Deemed permission.
Interesting. And how long does a government order on closure, granting or refusing, remain valid?
Generally, the order is final and binding for 1 year from its date.
But subject to review.
Yes, subject to the government's power to review its own order or refer it to a tribunal if needed. Okay. The IR Gazette also lists penalties for illegal strikes and lockouts. What kind of penalties are we talking about?
They can be quite significant. An employer starting or continuing an illegal lockout could face a fine between 50,000 and 1 lakh rupees, or up to 1 month imprisonment, or both.
And for instigating illegal actions.
Someone instigating or inciting an illegal strike or lockout faces penalties too, a fine from 10,000 to 50,000 rupees, or up to 1 month imprisonment, or both.
So, penalties for both employers and instigators. How does the code handle offenses by companies? Who's liable?
It's fairly standard corporate liability. If a company commits an offense, the person in charge of and responsible for the business at that time and the company itself are deemed guilty.
Can the person in charge avoid liability?
Yes, if they can prove the offense happened without their knowledge and they exercise all due diligence to prevent it.
Due diligence defense.
Right. Also, if the offense happened with the consent, connivance, or neglect of a director, manager, secretary, or other officer, then that individual is also deemed guilty and liable for punishment along with the company.
Spreads the responsibility. Can proceedings be moved between tribunals, like from a state tribunal to the national one?
Yes, the central government has the power to do that. It can withdraw a case pending before any tribunal, central or state constituted, and transfer it to a national industrial tribunal for final decision.
Why might they do that?
Maybe for cases of national importance or complex cases needing the specific expertise of the national tribunal, or to consolidate related cases. The National Tribunal can then either restart the case or pick it up from where it was transferred.
Okay. The IR Gazette also listed unfair labor practices by employers. Can you give some examples?
Sure. It includes things like interfering with workers' rights to organize or bargain collectively. Establishing employer-dominated or sponsored unions is also unfair. Showing favoritism to one union over others, unless it's the recognized one, is out.
What about discrimination?
Definitely unfair. Discriminating against a worker to encourage or discourage union membership is prohibited. For instance, firing or punishing someone just because they urged others to join a union or because they took part in a legal strike.
Punishing participation in a legal strike is unfair. Got it.
Exactly.
Now, that laborcoding.pdf document gave some overarching objectives for these codes. What were the big goals mentioned?
It highlighted a few key aims. Achieving Social Security for everyone, establishing a right to security for workers in all situations, and significantly, aiming for an end to disputes through clearer laws and better resolution processes. A vision for a more secure and harmonious workplace.
The historical context in that PDF was interesting too. Labor laws weren't really touched during the big 1991 economic reforms. What pushed these reforms forward more recently?
The document suggests that the momentum really picked up after the successful implementation of the Goods and Services Tax, GST.
Ah, the One Nation, One Tax success.
Exactly. That achievement seemed to create the confidence and political will to tackle another complex area, the tangled web of old labor laws. The idea was to bring the same spirit of consensus and decisive action to labor reforms, aiming for inclusive growth.
Makes sense. That PDF also specifically mentioned the OSH code helping interstate migrant workers. How does it aim to do that?
It addresses shortcomings in the old 1979 Act. Previously, only workers hired by a contractor who moves states were formally recognized.
Okay.
The new OSH code allows workers to voluntarily register themselves as interstate migrant workers on a national portal.
Self-registration.
Yes. This gives them a formal legal identity as a migrant worker, making them eligible for Social Security benefits and other support services in the state where they are working. It enhances their protection significantly.
That sounds like a big improvement. The PDF also included remarks from the Prime Minister on the reforms. What key points did he emphasize?
He stressed the goal of a simpler, more accountable system, aiming for one registration, one license, single return for all codes to cut red tape.
easier compliance.
Yes. He highlighted the new Social Security Fund for the estimated 40 crore unorganized workers, including gig platform workers, to bring them into the safety net.
Crucial coverage expansion.
He stated the reforms are pro-worker, ensuring benefits and Social Security even for fixed-term employees. And he outlined expected outcomes: more employment, effective minimum wages, Social Security for the informal sector, less government interference, timely wage payments, and a strong focus on occupational safety.
So benefits for both workers and businesses.
That was the message. Simplifying 44 old laws into 4 modern codes leads to easier compliance, attracts investment, and creates a win-win.
There was also an infographic in that PDF about universalizing Social Security. What did it highlight?
It visually showed the expansion of ESIC, Employees State Insurance, applicability to all 741 districts nationwide.
Full country coverage.
Yes, mandatory for establishments over 10 employees, but also allowing voluntary coverage even for smaller places, which is a big deal.
Voluntary option is new.
Yes. It reiterated the schemes for unorganized, gig, and platform workers. And importantly, he pointed out there's no wage limit for ESIC coverage in hazardous occupations. Safety net regardless of income in risky jobs.
Okay. Now, the OSH Gazette, oshgazette.pdf, obviously has its own detailed definitions relevant to safety and health. We've covered many general terms, but anything unique here?
Well, it defines terms specifically in the OSH context. Things like adolescent, referencing the Child Labor Act, adult, 18 plus, agent, for mines. It clarifies appropriate government for OSH matters.
Right.
Defines banking company, contractor, controlled industry, core activity, again with its exclusions. Clarifies dock worker, gives a broad employee definition, family, go down, hazardous substance, industrial premises, medical officer, metro railway. A very thorough on mines across the board.
It is. Also, motor transport worker, newspaper establishment, office of the mine, plantation, prescribed, worker with the usual exclusions, and working journalist. It contextualizes these terms for safety and health regulation. The OSH code also requires registration for certain establishments. What do employers need to do regarding notifying authorities?
Employers running factories, mines, using contract labor, or involved in building construction work must notify the prescribed authority when they start operations.
Notify at commencement.
Yes, within a set time frame. And they also need to notify if they permanently cease operations.
What about when they close down?
Within 30 days of closing, they must inform the registering officer and certify that all worker dues have been paid. Once that's confirmed, the officer removes them from the register and cancels their registration.
Certification of dues paid is key.
Absolutely.
The OSH code also puts duties on people beyond the direct employer: designers, manufacturers, importers, suppliers. What are their responsibilities?
That's right. Safety is a shared responsibility. These parties have a duty to ensure, as far as reasonably practicable, that the articles or substances they design, make, import, or supply are safe and healthy when used correctly.
So safe design and materials.
Yes. They also need to carry out necessary testing and research to identify and minimize risks. And they must provide adequate information on safe use, warnings about hazards, and details of testing.
Does this apply indefinitely?
The duty applies to things done in their business and within their control. They don't necessarily have to repeat tests if they've reasonably relied on credible existing data.
Okay. What about architects, project engineers, designers involved in construction? Do they have specific OSH duties?
Yes, particularly at the planning stage. They are legally required to ensure safety and health aspects for the workers who will build and operate the structure are considered right from the design phase.
Building safety in from the start?
Exactly. A proactive approach to prevent hazards on site later.
The OSH code sets up a National Occupational Safety and Health Advisory Board. Who's on it?
It's composed of senior figures from relevant bodies: the Director Generals of Factory Advice Service and Mine Safety, the Chief Controller of Explosives, the Chairman of the Central Pollution Control Board, the Chief Labor Commissioner,
Few regulatory heads.
Yes, and also the Principal Secretaries for Labor from 4 states, serving on rotation. Ensures a wide range of expertise, advises the government on OSH policy nationally.
What powers does the appropriate government have under the OSH code regarding worker welfare and safety rules?
They have significant powers. They can prescribe rules for welfare facilities. Employers must provide like creches, canteens, restrooms, first aid.
The essentials.
Yes, they can set rules for appointing welfare officers in larger establishments, factories, mines, plantations with 250 plus workers, including their qualifications and duties.
Welfare officers for bigger places.
Right, and for construction workers, the government can mandate employers provide temporary living accommodation near the site, free of charge, and regulate its standards and duration.
Accommodation for construction workers. Okay, what about working hours? Is there a weekly limit?
Generally, yes. The code says no worker should work more than 6 days in any 1 week.
6-day week max. Any exceptions?
There's one specific one for motor transport, to avoid disrupting services. They can require work on a weekly holiday, but only if the schedule ensures no more than 10 consecutive work days without a full 24-hour break.
Okay, some flexibility for transport.
And the government can also grant exemptions for specific worker categories by notification, with conditions.
Employers have to keep records under the OSH code. What kind of information?
A lot. Details about workers, hours worked, wages paid and receipts, leave taken and wages for leave, overtime, daily attendance, records of any dangerous occurrences or accidents.
Comprehensive records.
Yes. Also specific records if they employ adolescents. They need to display required notices at the workplace. And they must issue wage slips, electronic or physical detailing earnings and deductions each wage period.
Wage slips are mandatory. Okay, the code uses the term inspector cum facilitators. What's their role and what powers do they have?
Their role is to oversee the implementation of the OSH code. They're appointed by the government for specific areas or establishments.
And their powers?
Quite extensive. They can enter workplaces, inspect premises and work, demand records, examine employees, and investigate accidents or dangerous occurrences.
Standard inspection powers. Any special powers?
Yes, particularly in factories and mines. In factories, they can issue orders prohibiting work in hazardous conditions until the danger is fixed.
Stop work orders.
Yes, if there's imminent danger. In mines, they can issue notices to remedy dangerous conditions or practices. If the notice isn't complied with, they can prohibit employment in that area or even prohibit certain types of mineral extraction if it's deemed unsafe or if fire flooding precautions are inadequate.
So significant enforcement power, especially in high-risk sectors.
Absolutely. And importantly, they are legally bound to keep the source of any complaint confidential unless the complainant consents. Protects whistleblowers.
That's good. What about licensing for contractors using contract labor? Is it always needed?
Generally, yes. Contractors employing contract labor need a license. There might be thresholds based on worker numbers and some exceptions, but it's the general rule.
How do they get one?
Through a prescribed application process, usually involving fees and providing a security deposit. Licenses are typically valid for 5 years and specify the maximum number of workers allowed.
What if they need more workers later?
They have to apply to amend the license, possibly needing a larger security deposit. And if a contractor defaults on wages, the government can order payment from that security deposit.
A safeguard for workers' pay.
Yes. Contractors also have to give experience certificates to contract laborers on demand, detailing their work and duration.
Can the government ban contract labor in certain activities?
Yes, the appropriate government can prohibit employing contract labor in the core activities of an establishment.
But there are exceptions.
Yes, if the activity is normally done by contractors anyway, or if it doesn't need full-time workers, or if there's a sudden surge in work needing temporary help, those might be exceptions. The government can also appoint an authority to advise on what constitutes a core activity.
Okay. What specific duties do contractors' employers have towards interstate migrant workers under the OSH code?
They have a primary duty to ensure suitable and safe working conditions for them.
Right.
If there's a fatal accident or serious injury, they must report it to authorities in both states, work state and home state, and to the worker's next of kin.
Dual reporting.
Yes. And they must extend all statutory benefits available to other workers like ESIC, EPF, medical checkups to the interstate migrant workers too. Equal treatment.
Good. The code also mentions audiovisual workers. What protections are there for them?
Agreements between producers and audiovisual workers need to be registered with a competent authority.
Registered agreements?
Yes, in a prescribed format, detailing the worker's particulars. And crucially, if the worker is hired through a contractor, the agreement must state that the producer is liable if the contractor fails to pay wages or dues.
Producer liability as a backup.
Exactly. Provides an extra layer of security for the worker. The producer can then recover the cost from the contractor.
What about BED and cigar workers? Any specific provisions?
The code acknowledges that much of this work happens in private homes, not factories. It allows for some exemptions from certain provisions for self-employed workers in their own dwellings.
Right.
But for those working in industrial premises making beedies or cigars, the standard OSH provisions generally apply. There might be specific rules tailored to the hazards of that industry, too.
Okay. For factories with hazardous processes, there's a requirement for information disclosure. What needs to be disclosed and to whom?
This is a major safety measure. The occupier must disclose comprehensive information about the dangers involved, health hazards, safety measures needed, details on handling, storage, transport of hazardous substances.
Full transparency on risks.
Yes. And this info must go to several groups: the workers themselves, the inspector-cum-facilitator, the local authority, like the municipality, and the general public living nearby.
Public disclosure, too. Interesting.
Yes, ensuring community awareness of potential risks. The state government prescribes how this disclosure happens.
What about safety on plantations? What must employers provide?
They need to provide washing and bathing facilities, clock rooms, and protective clothing equipment for workers handling hazardous substances like pesticides.
PPE and hygiene facilities.
Yes. And they must display lists showing the permissible safe concentration levels of these hazardous substances in the worker's breathing zone.
Okay. Penalties under the OSH code seem quite varied. Can you give a quick overview?
It's a tiered system. General contraventions can lead to fines from $50,000 up to $1 lakh. Repeat offenses can bring imprisonment up to 3 months, or higher fines up to $2 lakh, or both.
Heavier penalties for repeats.
Yes. Violating rules on working hours or leave has specific fines, $25K, $50K, with escalating penalties for repeats, potentially reaching 6 months jail or fines up to $2 lakh.
Okay.
Failing to furnish required plans or records can mean fines of $2 lakh. Falsifying records could lead to 6 months jail or fines of $50K, $1 lakh, or both. Unauthorized disclosure of confidential info carries penalties too, but needs government sanction to prosecute.
So penalties align with the severity and repetition of the offense. Can employees face penalties too?
Yes, if an employee breaks a rule in a way that endangers others, they can be penalized. However, the employer isn't automatically guilty in such cases unless they fail to take reasonable steps to prevent it. It emphasizes employer responsibility for systems, but individual accountability too.
What about prosecuting mine owners or managers? Any special procedure?
Yes, prosecution against a mine owner, agent, or manager can only be initiated by the chief inspector-cum-facilitator, the district magistrate, or an inspector specifically authorized by the chief inspector. Needs high-level approval.
Is there a way for owners, managers to be exempt from liability?
Yes, the due diligence defense exists here too. If they can prove the offense happened without their knowledge and they did everything reasonably possible to prevent it, they might be exempt.
Okay. And offenses by companies. Similar rules as the other codes.
Yes, very similar. The person in charge and responsible for the business at the time, plus the company itself, are liable. The due diligence defense applies, and directors, managers, officers are liable if the offense occurred with their consent, connivance, or due to their neglect. Consistent approach.
The OSH code mentions an adjudicating officer imposing penalties. How does that work?
The government appoints these officers to inquire into alleged contraventions. They have powers like a civil court, summoning witnesses, taking evidence under oath, requiring documents.
An inquiry process.
Yes, they give the accused a chance to be heard. If satisfied an offense occurred for the specific violations they handle, they can impose a penalty within the code's limits, recording their reasons in writing.
Can you appeal the adjudicating officer's decision?
Yes, an appeal can be made to a notified appellate authority within 30 days of receiving the order, with possible extensions for sufficient cause.
What does the appellate authority do?
They hear the appellant and can confirm, modify, or set aside the adjudicating officer's order, usually within 60 days. Provides a review mechanism.
The code also allows for composition of offenses. What does that mean?
It's basically settling certain, usually less serious offenses by paying a sum of money instead of going through a full court prosecution.
Paying a fine to settle it.
Essentially, yes. The government sets rules on which offenses can be compounded and the amount payable. The money collected goes into that fund for unorganized workers' welfare.
Connects back to the welfare fund.
Yes. But compounding usually isn't allowed for repeat offenses within 3 years of a previous compounding or conviction for the same offense.
Discourages habitual violations.
Okay. Does the OSH code itself mention that Social Security fund for unorganized workers?
Yes, it does, specifically stating that the money collected from compounding offenses under the OSH code goes into that fund. It shows the linkage and integrated approach across the codes for funding unorganized worker welfare.
In public emergencies, can the government grant exemptions from the OSH code?
Yes. In situations like war, external aggression, internal disturbance, disaster, or pandemic, the government can notify exemptions from all or parts of the code. For how long?
The notification specifies the scope, duration, and any conditions. But an exemption can't last more than 1 year at a time.
Okay, temporary emergency powers. Both central and state governments can make rules under the OSH code. Do they handle different areas?
Generally, yes. The center often handles rules with national scope, or for industries it controls, or specific areas like safety and docks, detailed in Schedule 3.
Docks are central.
Yes. States usually make rules for more localized matters or specific industries within their borders, like plantations, matters listed in Schedule 2, welfare, working hours, leave. Both levels prescribe forms, procedures, etc. for implementation.
And finally, for OSH, the repeal and savings section. Which old laws are gone and what happens to actions taken under them?
It formally repeals major acts like the Factories Act 1948, Mines Act 1952, Dock Workers Act 1986, Building and Construction Workers Act 1996, and others. They cease to exist once the OSH code fully kicks in.
Okay, and the savings part?
That's crucial for continuity. It means things done under the old laws, rules, notifications, orders, appointments, are considered valid under the new OSH code, as long as they aren't inconsistent with it. They remain in force until specifically superseded by new rules under the OSH code. Prevents a legal vacuum.
Smooth transition. Got it. Schedules 1, 2, and 3 list hazardous industries, plantation rules, and dock safety regulations, respectively.
Correct. They provide specific details supporting the main code.
Okay, let's refocus on the Social Security Code Gazette. We know its scope and commencement. What about specific applicability rules for EPSF and ESI?
Right. Chapter 3, EPF Provident Fund, generally applies to establishments with 20 or more employees.
20 plus for EPF.
Yes. But there's an opt-out possible if the employer applies and can show a majority of employees agree, perhaps if they have a comparable existing scheme.
Okay, what about ESI?
Chapter 4. ESI employee state insurance generally applies to establishments with 10 or more persons, but excluding seasonal factories.
10 plus for ESI, excluding seasonal.
However, ESI also applies to any establishment, regardless of size or being seasonal, if it involves hazardous or life-threatening work notified by the center, even if there's only one employee.
Safety net for hazardous work, regardless of size.
Exactly. And there's also that voluntary coverage option we mentioned earlier. Smaller establishments can opt into ESI if the employer and a majority of employees agree. Plus, the government can notify its application to other types of establishments too. The first schedule details these applicability rules.
Chapter 2 of the SS Code sets up Social Security organizations. Can you outline the main ones and their functions?
Sure. The big one for EPF is the Central Board of Trustees of the Employees Provident Fund, the Central Board. It administers the PF, pension scheme, and insurance scheme under Chapter 3. Its members represent employers, employees, central state governments, etc.
Okay, the EPF board. What else?
There's the National Social Security Board. Its job is to recommend schemes for unorganized, gig, and platform workers, monitor them, and advise the central government. It has diverse members from various fields and stakeholder groups.
Advising on the unorganized sector.
Yes. Then, at the state level, each state must set up a State Unorganized Workers Social Security Board. Chaired usually by the state labor minister, it implements schemes, registers workers, collects contributions at the state level.
State level implementation.
Right. And similarly, state building workers' welfare boards are constituted to manage welfare schemes and collect the cess specifically for construction workers.
Okay. And there are rules about board members.
Yes, rules about removal of members and, importantly, requiring disclosure of financial interests by company directors on these boards to avoid conflicts. The central government can also issue directions to these organizations.
Chapter 3 focuses on the EPF, key administrative points. Contribution rules.
It establishes the Central Provident Fund Commissioner as the CEO of EPFO. The board appoints other officers. Regarding contributions, if workers are hired via a contractor, the contractor can be held responsible for remitting both employer and employee shares.
contractor responsibility.
But the contractor cannot deduct the employer's share from the worker's wages. Protects the worker from bearing the employer's cost. Chapter 3 also allows exemptions for establishments with comparable existing PF schemes or those in financial difficulty, subject to conditions.
Chapter 4 is about ESIC. What are its main functions and benefits?
ESIC administers the ESI scheme. Its functions include providing benefits, setting up hospitals, dispensaries, and collecting contributions. All employees in covered establishments must be insured.
What benefits does ESI provide?
A range: sickness benefit, cash during illness; disablement benefit for employment injury, temporary or permanent; dependence benefit if death due to employment injury; medical benefit, healthcare access; maternity benefit, and potentially an unemployment allowance if a scheme is framed.
Comprehensive benefits.
Yes. The code presumes accidents during work arise from work. Medical boards assess disablement. The corporation can run its own hospitals or partner with others. State governments can share medical benefit costs. And crucially, schemes can be framed under this chapter to cover unorganized gig and platform workers too.
Extending ESI-type benefits, potentially. Okay. Chapter 5 sets up employees' insurance courts. What do they handle?
These state-level courts handle disputes specifically about the ESI scheme.
Like what?
Disputes over whether someone is covered, wage rates for contributions benefits, entitlement to benefits, liability for contributions, recovery of unpaid contributions. Their orders are enforceable like civil court decrees. Procedures and fees are prescribed by the government.
So, a dedicated judicial forum for ESI issues. Chapter 6 deals with gratuity. Who gets it? How is it calculated and paid?
Gratuity generally applies to establishments with 10-plus employees. Eligibility usually requires 5 years continuous service, less if death disablement.
Payable on.
Superannuation, retirement, resignation, or death disablement. Calculation is typically 15 days' wages per completed year of service, or part over 6 months, capped at a notified maximum.
Can it be forfeited?
Yes, for certain misconduct causing damage loss or for riotous, disorderly conduct.
How is it paid?
Employer determines the amount, notifies the employee authority, and must pay within 30 days of it becoming due. Delay attracts interest. Employers, non-governments, might need compulsory insurance for this liability unless they have an approved fund. Competent authorities handle implementation and disputes.
Chapter 7 covers employees' compensation again. Any extra details on procedures?
It reiterates employer liability for injury death from accidents arising out of and in the course of employment, with exceptions for intoxication, willful disobedience of safety rules, or removing safety guards.
Can't claim if you sue in civil court.
Correct. And vice versa. No double dipping. Employees need to give notice of accidents. Employers can require medical exams. Claims go to the competent authority. Employers might need insurance. For fatal accidents, compensation is deposited with the authority, who can ask for more if needed. Procedures involve evidence recording, possible reference of legal questions to the High Court, and appeals to the High Court on certain orders.
Chapter 8 is the Building and Construction Workers Welfare Cess. Purpose and collection.
Purpose is to fund welfare schemes for these workers. It's levied on the costs of construction, rate notified by Center, max 2%. Collected usually by local authorities or notified bodies, then deposited with the State Building Workers Welfare Board. Collection might be based on estimates initially, with final adjustment.
Okay, dedicated funding stream. Chapter 9 was Social Security for unorganized workers. Chapter X then talks about information, records, returns, and a toll-free call center. What's the focus there?
Chapter X is about ensuring unorganized, gig, and platform workers know about and can access their potential benefits. Schemes might require registration and info submission. Crucially, the government can set up toll-free call centers or helplines, plus physical facilitation centers, to provide information and help workers register. It's about bridging the information and access gap.
Making it easier to participate. Good. Chapter S deals with finance and audit of the Social Security organizations, dedicated funds, budgeting, audits. Chapter 12 covers the inspector cum facilitator for the SS code. Similar powers to OSH.
Yes, broadly similar inspection powers. But here, they also specifically have the power to assess and determine dues for EPF, ESI, and gratuity. They're involved in recovery, too, via recovery officers using Income Tax Act procedures. And employers can't reduce wages during an inquiry.
Okay. Chapter 13 outlines offenses and penalties under the SS Code. Chapter 14 has miscellaneous provisions like reporting vacancies to career centers, though no obligation to hire from them, and stating the SS Code overrides inconsistent laws.
Correct. Chapter 13 covers penalties, prosecution procedures, sometimes with a chance to comply first, court cognizance. Chapter 14 has those miscellaneous points, including the overriding effect, government power to make rules and remove implementation difficulties within 2 years, and the final repeal and savings clause for old Social Security laws, plus the schedules detailing applicability, employee definitions, contribution rates, injury lists, occupational diseases, wage periods, aggregator classifications, etc.
Phew. Okay, finally, the Code on Wages, 2019. It covers minimum wages, deductions, bonus payments, claims, and appeals. Give us the highlights.
Right, the Wages Code applies across India, starts on notified dates. Chapter 3 lets the appropriate government fix minimum wages, time and piece rates, ensuring minimum time wage for piecework. Can be hourly, daily, weekly, monthly, etc.
What about deductions from wages?
Chapter 4 strictly regulates them, only allowed for specific things. Fines, absence, damage due to neglect, house accommodation services provided, recovery of advances loans, PF contributions, income tax, court orders, subscriptions, insurance premiums.
Is there a limit?
Yes. Total deductions generally can't exceed 50% of wages in a period, with some exceptions. Fines need government approval, and employee must get a chance to explain. Loan recovery deductions are also regulated.
What about bonus payments?
Chapter 4 again applies generally to establishments with 20-plus people, calculated based on a lockable surplus from profits. Minimum bonus payable even with no profit. Maximum bonus also capped. Rules for set on and set off of surplus across years. Formula for gross profit provided may differ for banks. Misconduct can disqualify an employee from bonus. Certain establishments, RBI, some institutions, specific contractor employees, etc., are exempt. Bonus must be paid within 8 months of year end. Unpaid bonus goes to nominee heir or deposited with authority.
How are disputes over wages or bonus handled?
Chapter 5 sets up authorities to hear claims. They can order payment of dues plus compensation, up to 10 times the claim. There's an appeal mechanism. Audited accounts are presumed accurate in proceedings.
And inspectors? Burden of proof?
Chapter 7 appoints inspector-cum-facilitators with inspection powers. Chapter 8 puts the burden of proving wages bonus were paid on the employer if a claim is made. And importantly, any contract where an employee gives up their right to minimum wage or bonus under the code is void. Protects workers' rights.
Well, that was indeed an incredibly thorough deep dive. We've navigated a vast amount of information from all the sources you provided.
We certainly covered a lot of ground.
Aiming to create for you, our listener, that comprehensive audio resource covering the key aspects of the Indian labor codes and Social Security provisions.
Absolutely. We've really tried to pull out every pertinent detail, hopefully offering a clear overview that can act as a useful, accessible alternative to wading through all the original legal documents.
So listeners should now have a pretty solid foundational understanding of these complex frameworks, the scope, the definitions, how disputes are handled, Social Security, OSH, wages.
Yes, the whole landscape.
So, considering the sheer breadth and depth of these codes that we've explored, what are your final thoughts? How might these provisions collectively shape the future of work and that dynamic between employers and employees in India? It really feels like a significant shift.
That's a really profound question, and perhaps one best left for you, our listener, to reflect on now. We encourage you to maybe revisit specific sections that caught your attention, or delve deeper into areas relevant to your own work or life. These labor codes, they represent a substantial transformation. Understanding their details, their nuances, will undoubtedly be crucial for everyone navigating the future of work in India, whether you're an employer or an employee.